That's us now live, Dan.
Good morning, everyone. It's time for us to make a start. My name is Dan Jackman, and I'm the reporter appointed by Scottish ministers to carry out an examination into the planning appeal against the refusal of planning permission by West Lothian Council for the erection of 104 houses and associated development on land at HENS Nest Road, East Whitburn. In a minute, I shall explain how we'll conduct today's hearing session. However, there's an important preliminary matter. If we're all in the same venue, it would be very easy when I directed a question at one or other of the parties for who was intended to answer. So what I suggest is certainly for the council and appellant that they nominate a team leader who I'll initially direct my questions to, and it will be for them to decide who in their team will answer and to indicate when their team has finished. Can I ask then who will be the team leader for the appellant?
Stuart Salter, Geddes Consulting, will be the team leader for the appellant.
Okay, thank you. Perhaps you could introduce your team for me, please.
With me here in the office today, I have Rob Miller, landscape architect, Geddes Consulting. I have Callum, Callum Glyde, planning consulting, Geddes Consulting. We have with us also Lee Houghton from Brinley's, landscape architect. And we have Emma Dewar, lawyer, Furnace Bond.
Thank you. And for the council, who will be your team leader?
Yes, good morning, Mr. Jackman. Craig McCorriston, Head of Planning, Economic Development and Regeneration with West Lothian Council, and I will lead for the council.
Okay, and perhaps you could introduce your team for me.
Yeah, thank you, will do. With me today are Steve Lovell, who is a Principal Officer from Development Planning. I've got Tony Irving, who is a Principal Officer from Development Management, and Malon Fatua, who is the Case Officer for the application. We're also supported by Leslie Montague from the Council's legal team. Thank you.
Okay, thank you. Mr. Hogg, I will normally initially direct my questions at either the council or the appellant because they usually have the most things to tell me, and there are certain things that the law requires me to make sure I understand from the planning authority and the appellant. Please don't think I'm ignoring you, and I will always check in before I move on to a main section of the hearing.
Well understood.
Well, I'm now going to explain how we'll run today's session. I shall start each item of the agenda by directing a question at one of the parties. As I've just said, it will be the responsibility of the team leader to indicate who in their team will answer and confirm when their side has finished. After I've had that answer, I will invite the other parties to comment in turn. And depending on the nature of the replies, either I will move on or we will have a further discussion. Occasionally, I might have a series of questions for one party. If that's the case, I shall say so, and I always ask the other parties to comment before I will move on. Because of the virtual format we're using today, it's especially important that you don't talk over each other. So please wait your turn. There will be plenty of opportunities for you to tell me whatever it is that you need to tell me. Obviously, all the hearing sessions are interrelated. My main aim for hearing session 1 is to understand the main party's position on whether the proposal complies or not with the relevant provisions of the development plan and their opinions on the material considerations. For hearing session 2, I have some focused questions that I had. I don't want to spend our time going around in circles debating the merits of housing land supply methodology, so it's just focused on those particular points. Hearing session 3 would be exploring the council's views on some of the appellants' submissions, and I had some detailed questions of the parties as well. And hearing session 4 is looking at planning obligations and conditions. I'll repeat what I said at the pre-examination meeting. The fact that we have a hearing session on planning obligations and conditions does not imply that I've made up my mind. This is standard practice, and any discussion we have will be on a without prejudice basis. Some people think the purpose of a hearing session is to persuade me of their point of view. It's not. The purpose of the session is to make sure I understand your positions. I shall persuade myself when I reread all the material that is before me. I warn you now that I shall be adopting a brisk pace. Once I'm satisfied that I have the information I need, I shall move on. I shall politely intervene if I think we're losing focus or straying from the matters I think I need. And there's no need in answering the questions for you to repeat matters that is already before me. It's fine to just refer to your submissions, but if you're doing that, please make that reference clear so I can find them in my notes. Of course, today isn't the whole process. We've got an accompanied site visit tomorrow, and we also agreed at the pre-examination meeting that there will be exchange of closing statements. Is everyone clear how we're going to run today, or have any procedural points they need to discuss? Mr. Salter? Happy? Mr. McCorson?
Indeed, sir. Yeah, happy, and nothing to raise as procedural at this stage. Okay.
Can we start then on item 2A 1I? And my aim here is just to check my understanding of the main party's positions. I'm not looking to debate the merits. There'll be opportunities for that later on in the agenda. So I'm going to run through these things pretty swiftly. I'll just say what my understanding, and if the two main parties can just indicate whether they agree or not. So for the first bullet point, policy 1A, I think you both agree that West Lothian is a strategic development area, and that's relevant because it's referred to in policy 7. Is that right?
Yes, from the balance perspective.
Okay. Moving on then to policy 1B, if I can start with the question to the council. It seems to me that policy 1B is an instruction to local development plans. How is that relevant to a proposal for a planning application? And if so, how does the proposal actually breach policy 1B in your view?
So, Mr. Jackman, on hearing session 2, all the items under section 2 here, I'm going to pass over to Steve Lovell, who will lead from the council's perspective. So, Steve will address that question for you.
Good morning, thank you. Policy 1B identifies a number of obligations that the local development plans are required to fulfil. So to take these in turn, we have one was ensuring there are no significant adverse impacts on the integrity of international and local designations and classifications. Secondly, ensuring that there are no significant adverse impacts on the integrity of international and national built or cultural heritage sites. 3 was having regard to the need to improve the quality of life in local communities by conserving and enhancing the natural and built environment to create more healthy and attractive places to live. Fourthly, contributing to the response to climate change through mitigation and adaptation. And finally, having regard to the need for the quality design, energy efficiency, and the use of sustainable building materials. It's the Council's contention that the proposed development would have a significantly adverse effect on the locally designated countryside belt. It would not necessarily improve the quality of life for communities and could actually erode the natural environment and would be unsustainable and therefore detrimental to the efforts to respond to climate change and the climate emergency. Compliance with Policy 1B was specifically addressed and tested in a previous appeal decision relative to part of the site. That's DPA appeal reference PPA-400-2121. And I think it's helpful to recount that the reporter at that time said, "I consider that the appeal site comprises an important separate and functional area of countryside between East Whitburn and Whitburn. It forms a valuable visual and physical separation between the two settlements, and it contributes to the identity and setting of the village of East Whitburn." He went on to say that although there are modern housing developments nearby, she didn't consider the presence of such developments as a justification for further intrusion into the clearly defined countryside area between the two settlements. And the development of the site.
Can I just stop you there, Mr. Lowe? We'll get on to that later on in the agenda. I'm just really trying to check my understanding of the main party's positions on the actual policy. So you've answered my question. Thank you for that. For the appellant, I know you don't agree with that, but is there anything you'd like to add that you haven't already done so?
No, Policy 1B is a matter for the local development plan, so it's not part of the development management process for the appeal proposal.
Okay, thank you. I've got your positions on that. So if we can now move to the next bullet points, and I'm wondering if I can be so presumptuous as to guess that both of you would agree that policy 5, 6, and 7 could be considered as a package of interrelated policies. And in summary, the appellant's position would be that there is a housing land shortfall, that policy 7 is engaged, and that all the criteria are complied with. The council, on the other hand, would say, as their primary position, there's no shortfall, but if there was, in any event, the proposal would breach criteria A. Have I picked all that up right?
Yes, I don't think we would disagree with that summary.
We wouldn't disagree with that summary either, sir. I think we would like to point out something from the SES Plan supplementary guidance, if that's okay.
Yes, of course, yes.
So the council's document, a submitted document, CD002, which is the SES Plan supplementary guidance. Paragraph 3.12 of that document sets out the delivery, what the purposes of delivery. So I've got two mice here. At paragraph 3.12, it states maintaining a supply of effective housing land supply for at least 5 years at all times in accord with approved SDP policy 6 and policy 7 should ensure that there's a continuing generous supply of land for house building. Member authorities will base their calculation of the 5-year effective land supply on the period 2009 to 24, taking into consideration housing completions. SES Plan, in conjunction with member authorities, will monitor the supply of housing land on an annual basis in order to assess progress against the overall housing land requirement. And just to be clear, that's the housing supply target in terms of SES Plan, set out in table 3.1. That is the residual methodology. And I just want to be clear on that. That is what the residual methodology does. And that's the only statement to that effect I will make.
Right, we'll get on to methodologies in hearing session 2. The council want to come back on any of that?
No, not specifically. No, I'm quite happy to leave that there.
Okay, thank you. Let's now move on to policy 8. And again, if I can start with the council. Looking at policy 8, which particular criteria or criterion would you argue is breached by the appeal proposal?
Thank you. Policy 8 seeks to ensure that new development minimises the generation of additional car traffic, and that includes through the application of modal share targets and car parking standards that relate to public transport accessibility. Because the appeal site lies out with the settlement envelope of both East Whitburn and Whitburn, it's considered to have a relatively low accessibility to the necessary services and the community facilities. And as a consequence, the council feels the development of the scale and the nature proposed at this location would likely result in a high proportion of these journeys being made by the private car and wouldn't contribute to the overarching sustainable travel and sustainable development objectives of the development plan and also national planning guidance.
But which particular criteria would you point me to? Or are you just saying it's contrary to the overall objective?
So if you just bear with me a second. I think it's really the overall objectives of that particular policy that we find it being not satisfactorily compliant with.
Okay, thank you. Appellants, again, I know you don't agree, but is there any other points you'd like to make over and above what you've already told me?
The appellant's position is set out in the statement of appeal, paragraphs 3.4 to 3.4 to 5.7.
Okay, thank you. Noted that. If we move on to policy 9, I think you both agree that this policy is relevant, but that subject to conditions and an appropriate planning obligation, the proposal would comply. I take that people are happy with that. I'm seeing a nod. Okay, let's move on to policy 13. And again, if I can start with the council. Policy 13 seemed to me to be an instruction to the LDP. Again, how is that relevant to a planning application?
I think I'd just start off by saying that West Lothian doesn't contain any national landscape designations such as scenic areas, but there is certainly a concern about the impact of development on the local setting of many of the large and smaller settlements. And in preparing the local development plan, the council undertook a landscape designation review to underpin the LDP's natural environment strategy. The site is located in what it references as the Upper Ammon Valley Landscape Unit, and that's generally described as an area of marginal quality farmland. And whilst East Whitburn is not specifically mentioned by name, the review did indicate that the local landscape does make some contribution to the setting of several settlements on the periphery. The more relevant characteristic of the appeal site, however, is that it's identified as being embraced by the designated countryside belt, and that abuts the site to the west, the north and the south. The countryside in West Lothian is recognised as a finite resource, and the adopted West Lothian local plan tries to protect the area's valuable natural environment by setting up a policy approach which avoids sporadic development in the countryside, and that would erode its character and amenity. So that's the key issue which the council feels that this policy is pertinent.
Okay, thank you. And the appellant, again, I know you don't agree, but is there anything you want to add to anything over and above what you've already told me?
No.
Okay, thank you. Can we now move on to the West Lothian local development plan? And on the first bullet point there, I listed what I think are undisputed policies that you both agree that they are relevant, and again, subject to conditions and obligations, the proposal complies. Have I got that right?
Yes, sir, we would confer with that. Yep.
Okay, Mr. Salter, yeah? Yep.
Yes, sir.
Yeah, cool. Right, let's move on to the disputed policies then. And turning to DES 1, if I can ask a question of the council. In the submissions to me, you express non-compliance of DES 1 in the context of some very detailed road layout criticisms. Does that mean you think all the other criteria in DES 1 the proposal complies with, or is it more to that?
I think we have more general concerns about the compliance with DES 1. It's not just the roads issue.
Okay, so can we go to DES 1 then? Can you tell me which particular criteria you think the proposal breaches? So I don't know if you've got that in front of you, but there's A to H criteria. Which particular criteria? Okay, I noted the comments about the road layout, but which particular criteria there give you issues?
In particular, we're concerned about where it says being where a development is likely to have an adverse impact on adjacent buildings on streetscape in terms of layout, scale, massing and amenity, which the council contends that the development would. The criteria which says where there's no significant impact on landscape character, and again, the council contends that it would. And finally, where the proposed development is accessible for all, provides suitable access and parking, encourages active travel, and has no adverse implication for public safety. The council doesn't believe that the development of a site at this location would frankly do much to support or encourage active travel, and it feels that the policy is not satisfied in that regard.
Okay, thank you. So actually, you would refer me to the criteria A, B, and C. Yeah, thank you. Okay, for the appellants, any thoughts or comments on that?
The appellant set out the master plan document the statement of appeal document OH1 paragraphs 3.104 to 3.108 sets out why the proposal complies with policy DES 1. That includes reference to the master plan document PA 1.48 and the settlement and local character assessment OH4. It's worth noting that the matter raised by the council can be resolved by minor modifications, and those are capable of resolution by the way of condition rather than refusal. And this was confirmed in correspondence by the council on the 15th of October 2020, which is document PA 2.11.
Yes, and we'll come on to that in a later hearing session. I'm just trying to make sure I understand the main party's position on the main policies. I think your positions on how 1 and how 2 will mirror what we agreed over policy 5, 6, and 7. But can if I ask the council a question over policy how 2? I appreciate that your primary position is that how 2 is not engaged because you would argue that there is no shortfall. But if I was persuaded there was a shortfall, I'm assuming you would argue it's contrary to A, but what would be your position on criteria C and D of policy how 2?
I think, as I've already mentioned, we have concerns about the sustainability implications of the development, and so we certainly would be concerned that the development is not a sustainable development in terms of access and accessibility. In terms of the delivering development within the next 5 years, we appreciate that the developer has set out a programme for implementing that. It's challenging, but I wouldn't necessarily say that it wasn't achievable.
Okay, and again, we'll come on to that later in the hearing session. So your position is that even if I was persuaded that there was a shortfall, the proposal would fall against criteria A and C. For the appellants, again, I know you don't agree with that. Is there anything you would want to add to what you've already told me?
Really, sir, it's worth noting that in relation to the counting exercise that's required to be undertaken to the local development plan, the council is silent on its examination report and what the conclusions were reached by reports of Warren for the LDP examination. It is clear to the appellant that policy how-to was adopted to address report of Warren's conclusion that he found that the proposed plan is deficient in its failure to provide sufficient amount of land which is effective or expected to become effective in order to meet the housing supply target set out for the SDP for 2009 to 19, and consequently the overall housing supply target for the plan period to 2024. Scottish ministers approved and adopted that, directed the plan to be adopted on that basis. Ministers understood there was a housing shortage in West Lothian, and the council executive adopted the plan on that basis. So since the examination report was made available in September 2017, the correct policy response to that was policy 7 of SES plan, and once the plan was adopted in October 2018, policy how-to of the development plan. This is not a new issue. That's all I'm trying to clarify there, sir.
Yes, and I see that examination report is with me as one of your documents. Okay, we'll no doubt debate that more in hearing session 2.
Sir, can I just interject at that point? Apologies for doing so. I mean, clearly the appellant has made statements there about the position in relation to the examination. We would clearly want to respond to that position, but happy to do that in the land supply session, which is later today. If that is your intention to cover that at that stage, but we would want to address the points that have been made there.
Well, what I suggest is I'm actually on a mission at the moment just to try and find the parties' position on whether they comply with the policies, rather than getting involved in the whats and why-fors. We do have hearing session 2. I had some very focused questions on hearing session 2, but at the end I will make a note when I say any relevant points. Then you can come back and you can make your points about the examination report. Okay, I think I'm on policy ENV2, and I think your positions on that would be dictated by your positions on policy 7 and how to. Moving on to ENV7, can I ask the appellant? I think your position is, even if I was to find that there was no shortfall, the proposal would still, in your view, comply with policy ENV7. Have I picked that up correctly?
No. What would happen is policy ENV2 is part of policy ENV7, and that's the development in the countryside policy. That would stop this development. So this development wouldn't comply with the council's housing in the countryside policy. So however, in the event there is a shortfall, policy how-to overrides both policy ENV2 and policy ENV7, and that's explained in the examination report. So in relation to policy ENV7, that is identified, the examination report is OH 2.02. The page of the PDF is 1195. And the reporter's conclusion is at paragraph 3. what it says there is there is no need to reinforce those kind of provisions in ENV2. There are several other policies in this proposed plan which, if the approach was to be followed, would not be needed. I think it is similar to policy policy 7 on how to remain the most directly relevant policies should a shortfall in the housing land supply exist. So policy how to, if a shortfall is found, that is the determining policy. ENV2 is given limited weight in the determination. The same applies with policy ENV7, and that quote is said again on page 1084 of the examination report, paragraph 6.
Okay, thank you. Council, any comments on that?
Yeah, I don't think you can just set aside policies in the LDP that you don't like or don't actually happen to support the argument you're making. I think policy ENV7 is there and it has to have some regard taken of it, regardless of what conclusions reached on the shortfall.
Okay, thank you. I understand your positions. If we can move on to NRG 1, and if I can ask the council, you argue that this policy is breached because of it is not, in your view, a sustainable location because of poor access for active travel and public transport. Is that position mainly supported by the guidance in PAN 75?
Yes, and also other emerging policy on climate change and sustainability.
Okay, thank you. For the appellant, I don't think you would agree with that, but is there anything you want to add that you haven't already told me?
Thank you, sir. I'd just like to make the point that the Sustainable Development Assessment OH6 demonstrates the proposal's compliance, in our view, with policy NRG 1, the adopted LDP, and that's set out in paragraphs 2.42 to 2.106 of document OH6. Obviously, we stand by that assessment.
Okay, thank you. Mr. Hogg, I don't know what you made of all that, but is there anything you would like to tell me on the planning policies?
No, that's pretty clear. I'm trying to follow the notes I've got here. Clearly, my opinion and that of the residents echoes that of the council. So we're sort of nodding in agreement as we proceed at this stage.
Okay, right. If we can now turn on to 3I, and if I could start with the council, perhaps you can explain to me what the proper policy framework is for the provision of open space, both passive and active. Where would I find in the development plan the policy framework?
LDP policy DES1, that includes a provision for appropriately integrated and accessible infrastructure, and that includes open space, also green infrastructure, landscaping, etc., and also LDP policy ENV21 that addresses the protection of formal and informal open space from development. The West Lothian Local Residential Development Guide, which is supplementary guidance to the LDP, also sets out the council's position on the provision of open space associated with new developments, in that developers are required to ensure that new development provides residents with access to active open space and also should also meet the standards outlined in the Council's open space plan. The most recent open space plan was for the period 2020 to 2024. I'm not quite sure if that's been provided to you or not, but that could be.
Doesn't ring any bells.
Okay.
Obviously, the res development guide is a document before me. Let's see whether I need that because we'll be talking about this later on in hearing session 3. But I'm at this moment in time I'm just trying to focus on the policy framework. Okay, that's a helpful answer. So in relation to the actual appeal proposal before me, what's your position in relation to whether it complies or not with the open space approach of the council?
I think the situation on the ground are that there are a number of existing paths and areas of formal and informal open space within close proximity to the appeal site, and that includes some community woodlands. And on the whole, the council feels this adequately addresses the open space requirements of the village. And while we wouldn't be rash to dismiss opportunities to further supplement open space, it doesn't have to be at the expense of what we see as being other environmental considerations. So put simply, the carrot of new open space provision doesn't really outweigh the overall negative impact of the proposed development and the diminution of the countryside belt as a consequence. So, you know, as I say, the provision which is being suggested is not unacceptable, but it's not entirely necessary either.
Yeah. So if I can just paraphrase my understanding from that, is that you would say that the actual layout, notwithstanding your overall position about the development, the actual layout before me, subject to a planning contribution, would comply with the open space bit of DES 1 and the other associated policies.
Yes, I think I would agree with that, yes.
Okay. And what would be your position if there was no open space, active open space contribution?
Well, the policy requires that there should be, so we would be looking for some contribution that might be a matter for further discussion and agreement through condition.
Right. Okay. Again, we'll come back to that. That's helpful. Thank you. For the appellant, any thoughts or comments on what you've just heard?
Yes, I'll hand over to Rob Miller.
Yeah, so the open space plan requires that this development is to provide 5,741 square meters of active open space, and that's a calculation for 104 homes. We're providing above that at 6,950 square meters, which is actually an over provision of 1,209 square meters.
Can I just stop you there? Where did you get that calculation from?
So the calculation is based on the policy that's set out
in the open
space plan.
Ah, right. So that does seem to be a missing document. Okay. Sorry, I didn't mean to interrupt. But I hadn't seen a calculation in the residential development guide, but obviously there's a document which I haven't seen. So, sorry, carry on.
So in addition to this over provision of active open space, we're also providing 9,610 square meters of passive open space and 2,870 meters squared of structural planting, neither of which are required. So this proposal is actually massively over providing on both passive and active open space.
And sir, if it's helpful as part of the closing submissions, we will submit a plan to you that illustrates that. Yes,
we'll be discussing this later on in other hearing sessions where we can roll up our sleeves and get into the detail. I'm just interested in compliance with the policy at this stage. I don't think there's that much between you which we will not be already discussing later on. So I think I have what I need for that section. Are there any other relevant development plan policies we need to discuss? I'm not aware of any, but have we done all the material ones, the relevant ones? No one's waving frantically at me. I'm assuming that's agreement. Are there any relevant parts of the statutory supplementary guidance that we need to discuss other than the residential development guide? Again, I'm not seeing any frantic waving, so I'm taking that as agreement. Okay, can we move on to agenda item 3, starting with the Scottish planning policy? Perhaps I can start with the appellant's team. Both the development plan and SPP adopt, for want of a better term, an exceptional land release type policy approach when a shortfall occurs. In your view, are there any material differences between the development plan and SPP? Could you get different answers?
Yes. The development plan, SES plan, was adopted on the basis of meeting a housing supply target that is 18,010 homes over the period 2009 to 24. Scottish planning policy, as clarified through the Court of Session judgment, asks you to assess the housing land requirement over the period, and that is 19,811 homes over the period 2009 to 24. That is the major difference in the figure that you are to assess whether or not it's been met. In terms of how each is engaged, the presumption in favour of sustainable development places, so in all circumstances, so you do not need to understand a precise figure of the housing shortage. You only need to have indication, or so it could be whatever it is. What the housing shortage is, though, is a significant material consideration in the determination of the appeal. Paragraph 125 directs that the development plan policies for the supply of housing land will not be considered up to date. And paragraphs 32 to 35 are relevant in the determination of an appeal. Paragraph 33 is engaged, and the presumption in favour of sustainable development becomes a significant material consideration. The appeal proposal will remedy, if a shortage is identified, will remedy the housing shortage to some extent and contributes to sustainable development, which is what paragraph SPP is about. The appeal proposal will also provide economic gain. The question posed to the decision maker is whether there are any adverse impacts that significantly and demonstrably outweigh the benefits of the appeal proposal in terms of addressing the housing shortage and the economic gain provided. Before any assessment of the adverse impacts are placed on one side of the scale, the angle of the tilt is set by the level of housing shortfall determined. That's the tilted balance. The greater the housing shortage identified, the heavier the weight which tilts in favour of the housing proposal. Our view, and I don't know if we want to discuss this here. Obviously,
not really. so I want you to believe me when I tell you you're not the first person to talk about.
Sorry, you've just broken up there.
Oh, right. Okay, everyone's come back. That's okay. We must have had a wee gremlin. So it's really just to tease out whether there was any material difference between the kind of approach adopted in the development plan and the approach set out in SPP, rather than me not knowing how to apply SPP. But you've answered my question. That's very helpful. For the council, any thoughts or comments on what you've just heard?
Yes, thank you, sir. I'll respond to the matters raised very briefly. Sir, we don't have any real dispute in terms of what the numbers are. Where we do depart from the appellant is in relation to the question about how those figures are being met. The question from the council's perspective is, do those figures have to be met? There is clearly a difference in understanding and approach. There are clearly a number of material circumstances which have applied since all of the figures were set out in CES plan. Clearly the Scottish ministers had intended to address those matters. Their intention was clear in doing so. Perhaps the deployment wasn't as good as it could have been, but it doesn't change the fact that the Scottish ministers have made clear statements in terms of their intention about how the land supply should be calculated in the current circumstances. Sir, it remains a matter for the decision maker. Clearly, that is something that you are going to have to make your own decision on. We'll have a detailed discussion, no doubt, about this in the coming sessions in relation to it. But clearly, it is for you to reach your decision on that. We would ask you in doing so to have regard to the clear intention of the ministers in terms of identifying deficiencies in the current approach.
Yeah, I believe we're going to come into that a little bit later on in this agenda as well. But can I just come back to you there in terms of the actual question I asked Mr. Salter there? In your view, do you think there's any material difference between the kind of exceptional release policy that is set out in the development plan and the approach set out in SPP as clarified by the court?
Yes, sir. I suppose it depends in terms of what you, which court case you're referring to in terms of clarifying for the court. There's
Gladman 2.
Yeah. It seems to me, so that there isn't a significant difference here. I mean, SPP is SPP. It is unamended from the position in 2014. The SDP1 was adopted against that policy. So if there was any significant difference, we would have expected that would have been picked up at the time. So I'm satisfied that the approaches are compliant with one another, and I'd say the decision for you is how you interpret that given the current circumstances, and we would wish to advise you on that going forward. But in terms of compliance, we're happy that they are in alignment with one another. Okay,
thank you. I've recorded your comments there. Can we now just move on to the second point under SPP I had, and again, if I can start with the council. I take it from your submissions and what you've told me up to now this morning that your overall position is that the proposal before me does not contribute to sustainable development and would fail the principles set out in paragraph 29.
Yes, the paragraph, the SPP identifies a presumption in favour of development that contributes to sustainable development, and recent case law certainly reaffirms that it's a significant material consideration for the decision maker. We're completely in agreement with that. It requires the planning system to support economically, environmentally and socially sustainable places that enables development, but also balancing the costs and the benefits of the proposal over the longer term. And the aim is obviously to achieve the right development in the right place, but importantly, it does say not development at any cost, and that is one of the concerns that the council has. It sets out the principles of sustainable development and instructs policies and decisions, and it says it should be guided by a number of principles. I think there are 13 of them. I won't go through them, but paragraph 33 goes on to state that where relevant policies in the development plan are out of date, the presumption in favour of development that contributes to sustainable development becomes a significant material consideration. And I think that's what was being alluded to earlier. The tilted balance argument, which was raised in favour of granting planning permission, the court held that that was a significant material consideration, and it should be considered before the application is determined. Paragraph 125 SPC, it does say that when a shortfall in the 5-year effective housing supply emergencies, that the policy won't be considered up to date. But I think that's where Mr. McCausland was suggesting that we have issues with.
Yep. What I'm really interested to, so you've kind of tickled at an answer in terms of. Can I summarise what I'm taking from what you just said there? In your view, the proposal overall would not contribute to sustainable development because, in your view, the concerns over the landscape impact and the accessibility would outweigh any benefits. Have I picked that up fairly?
I think that's what I was trying to say. Yes.
Yes. Okay. Thank you. For the appellants, I know you wouldn't agree with that. Is there anything you'd want to add over and above what you've already told me?
Thanks, I'd just like to point you back to section 3 of OH6, the Sustainable Development Assessment, that provides a detailed assessment against each of the 13 principles of sustainable development set out in paragraph 29 of SPP. And we've also provided further commentary in document OH8, commentary on planning authority response, which introduces the tilted balance and also an assessment of the benefits or disbenefits of the proposal.
Okay, we're going to look in more detail at your sustainability assessment in session 3. So I've got the answer that I needed on that one. Are there any other relevant points in terms of the policy of SPP that we need to discuss? Okay. If we can turn to B, other Scottish Government guidance, if I can start with the Council, you've mentioned PAND 75 in relation to the various accessibility thresholds. In your view, are those thresholds absolute? If you're 1 meter over, are you out?
I think there's a degree of judgment would have to be exercised on that.
For the appellants, any comments on that?
Just if this is relation to sustainable walking distances, sir, obviously there's evidence before you that we are seeking to work with the council to provide bus stops that are closer to the proposal. But yes, it's a matter of planning judgment whether if you're 401, does that mean you're out? No, not at all. So it's just a matter of planning judgment in the state plan.
Okay, thank you. Are there any other Scottish Government guidance or advice that I need to be aware of are important to this appeal? I'm not aware of anything in your submissions. Okay, I take that as no. Are there any other guidance and advice that I should be aware of? I'm not seeing any frantic waving, so I assume again that's no. Okay, can we turn now to item 4? And if I can start with the appellant, in that agenda item, I tried to summarize matters which I think the council are inviting me to take into account as material considerations. Do you think any of those three are capable of being material considerations?
Things are capable of being material considerations, sir. It just depends, obviously, and you know this, it just depends what weight you attribute to them. The SES plan supplemental guidance was approved in 2014 and is over 5 years old. That's not debatable. However, the local development plan was adopted in October 2018 and it's less than 5 years old. The local development plan remains, the SES plan and the local development remain the approved development plan. The length of times of preparation of SES plans can be given material weight, but should be given very limited weight in the determination of the appeal. Do you want me to go on to the next item, or would you like?
No, please carry on.
Okay. The SES plan Honda 2 being considered robust and credible, again, that's a material consideration. However, it should be given very limited weight. The council, in its hearing statement, paragraph 3.21, agrees that the Honda 2 figures do not represent a housing supply target. Accordingly, this is not the number of homes which the planning authority has determined will be delivered over the development plan period. Therefore, it cannot be adopted to identify a housing land requirement. It's just not. It's just not appropriate to adopt that figure. The relevance of Honda 2 was discussed during the LDP examination, sir, where the council sought to introduce Honda 2 to supersede the SES plan figures. In addressing the matter of housing in demand and the appropriate housing supply target to be derived, Reporter Warren identified that whilst I note the council's concern that the adopted SDP housing supply targets are derived from Honda 1, I consider that the emergent position within proposed SES plan 2 can be given at best negligible weight at this stage. Honda 2, which forms part of the evidence base to inform policy decisions within proposed SES plan 2, cannot be used to make policy decisions on adjustments to housing figures within the proposed LDP. The proposed plan must accord with the adopted LDP. Accordingly, the evidence in Honda 1 derived the housing supply target for the approved development plan. The evidence in Honda 2 cannot be used for that purpose. It's also worth noting that this came up in the appeal submitted by the council, which was the Goshen appeal, PPA-400-2121. Reporter Shield, in that instance, considered this issue and concluded that, so this is summarized in OH 8.02, paragraph 22.
Yes, no, I've read that decision.
Yeah. And the position, so we can, I'll move on to the position of statement on draft MPF4. MPF4 is not published or approved policy and will not be so till summer 22 at the earliest, as I understand. So no weight can be attributed to MPF4.
Okay. Before I let the council come back on some of those points, can I just ask the council, have I been fair in summarising your position in those 3 bullet points as matters that you're inviting me to take into account as material considerations?
Yes, sir, that's correct.
Okay. So any points you'd like to make in response to the appellants there?
Yes, sir. A number of points, if I can. So in an earlier exchange, just in some of the policy positions, my understanding is that the appellant effectively accepted that we're at the end of the programming period in SDP1 So you'll be, in simple terms, sir, for the strategic development plan, you have no direction in terms of how the land supply should be calculated beyond the period of that strategic development plan. And so that might point you to paragraph 125 of SPP, which talks about development plans being out of date, and therefore the housing figures would be out of date. It is therefore, sir, if you were to accept that argument, you will have to find some alternative evidence in order to identify how you should calculate the housing land requirement or the housing land target. I don't accept the appellant's position that Honda 2 is not capable of that. It clearly is capable of that. It's a document which has been confirmed as robust and credible by the Scottish Government. So it is clearly a document that can form some basis and should have some very significant materiality, sir, in my view. Turning to NPF 4, when the Scottish ministers promoted changes to SPP, they had identified that NPF 4 would be published for consultation in September of 2021. We're clearly now, sir, in November 2021, and we haven't seen the consultation on NPF 4. What we have seen, though, sir, is a consultation on the housing figures, which are likely to be included in that consultation. The Scottish ministers have asked the council and other councils what they think the demand for housing will be over the period. Somewhat ironically, sir, I think we found ourselves arguing that the Scottish Government's figures were too low because they hadn't properly assessed the backlog of homelessness in West Lothian. So there's clearly a process there, sir, both through Honda 2 and NPF 4 that gives you an evidence base upon which to calculate the demand for housing. And the council's position is that helpfully both those processes give a very similar figure for housing demand in West Lothian. It's a figure of between 700 and 900 houses, depending on how you calculate that. It's certainly not, sir, a figure of 2,000 houses per annum, which the appellants would have you believe. Now, so where we are is that there's been a delay in publication of NPF 4. It's certainly the council's position that in a plan-led system, and again, the ministers were very keen to reaffirm that we're working in a plan-led system. The council, and more importantly, the communities which the council represents, should not be prejudiced because there has been a delay in progressing the plan-led system. If nothing else, sir, the decision at this point in time would be premature until those matters are clarified, and SPP makes reference to issues of prematurity where there is an emerging development plan position. So, sir, in summary, the matters set out in 4.1 are very significant material considerations from the council's perspective, and we would ask you to have regard to those and the figures which they throw up when you make the decision, so that you have to make, which is your preferred means of calculating the effective 5-year land supply. Thank you.
Okay, thank you. You're not going to agree on this matter between you, and I have the advantage, I know what questions I'm asking in hearing session 2, so I think I've got what I need on that particular item on the agenda. Can we then turn to 2I, And again, so if I can start with the councils, what conclusions would you invite me to draw from the previous planning appeal for this site?
Thank you, sir. At the time of that appeal, it can be interpreted from the decision letter, I think, that the reporter had sought out a definitive guidance on an agreed methodology for the calculation of the effective 5-year housing land supply, but alas found none. And while that guidance did subsequently come with the publication of PAN 1 2020, it was very quickly withdrawn due to a successful legal challenge, albeit one about process. So consequently, we're now effectively back in the same position as then, insofar as there's once again no definitive methodology for calculating the 5-year effective housing land supply. And as before, the reporter yourself has been tasked with weighing up the situation and deciding which to adopt. The council's expressed its concerns many times that it's an unsatisfactory position to be in, as it can, and indeed it would argue has created inconsistent planning decisions, and it doesn't believe that's a good position to be in at all. That said, the council took a significant degree of comfort from what the previous reporter's recognition and the conclusion that appeal site, the conclusion that the appeal site compromised an important, separate and functional area of countryside between East Whitburn and Whitburn, and that it provides a valuable visual and physical separation between the two settlements and contributes to the separate identity of both the village and the town. So it's the council's position that nothing really has substantively changed in the interim period, and it would invite the reporter to come to a similar conclusion with the outcome of this appeal.
Okay, I'll ask the appellant if they got any comments or observations on that. Just bear in mind that I have the previous decision on the agenda for session 3 as well.
Sure. So we will refer you to the appeal statement OH1 paragraphs 1.15 to 1.18, which sets out how the appeal proposal is substantially different and materially different to what was reviewed by the reporter last time. The matters of housing land supply we will discuss later. So I think it's a different proposal.
Okay.
Really different.
Thank you for that. Are there any other material considerations that we need, relevant material considerations that we need to discuss? I hadn't noticed anything in the submissions. Mr. McCarson?
Yeah, thank you, sir. I mean, it was really just building on the position in relation to the previous appeal, and I note your position that we will come on to discuss that later. You know, so the previous appeal found that it wasn't sustainable development. I recognise the appellant's position that it is a different proposal that is being tested by yourself. It's the council's position, so that you can tweak the boundaries and you can amend a development proposal as something that is fundamentally unsustainable under a previous test will continue to be fundamentally unsustainable. And sir, you know, I say nothing more that on the day that world leaders gather in Glasgow to look at issues of sustainability, I do think that you know, as a country, as a council, we need to have a greater focus on what sustainable development really means in terms of the climate challenge which we have. The council has declared that a climate emergency, and this, sir, is something that in the council's view goes against all the principles of sustainability, not just on a West Lothian stage, but a world stage. Thank you, sir.
Okay. And the parties can be assured we're going to roll our sleeves up and talk about this in relation to those principles in hearing session 3. Before I move on to the next session, Mr. Hogg, I don't know if you've got anything to to say after what was rather a planning techie session?
That was all very interesting, and took a few notes, but my position is obviously still the same with the council, so all good.
Okay, great.
Sorry,
if we-
before we finish, the department would like to just identify the two other material considerations,
Okay.
which is appeal decision PPA 2.102058, which is the Goshen Farm appeal decision. And also as referred to by the council in its committee report, there was the intentions notice for PPA 400-2097 Sibblesbury Bathgate, which is referred to the council. Those are two material considerations in terms of appeals. I'm not sure whether the intentions notice for Sibblesbury Bathgate is before you, sir. If it's not, we'd have to submit it again after this. I will take you through, but it's referred to by the council.
Right. Well, again, I'm sure the parties will understand that it's not uncommon for me to be referred to previous appeal decisions. The ones that are before me are before me, and I understood that any conclusions you wish me to draw had been set out in your respective statements, and I wasn't going to pursue that with any detail this morning. I think I understand where you're coming from on all those points. If you're introducing yet another appeal decision, then
it's already been referred to,
right,
and is material to the application of SES Plan Policy 7 and how to. It's just not been submitted before you, sir.
Well, if you want me to actually see an appeal decision, then it should be a document. And if there are conclusions you wish to draw, then what I suggest is that you leave that for your. No. If there's conclusions you want me to draw which you don't think have been expressed in the statements to date, then we'll need to discuss that at the end as to how we do further procedure. But make sure you think that's going to help me in making my decision. I'm not in favour of just reading stuff and
I absolutely agree, sir. It's yeah, absolutely noted.
Okay, right. Have we done on the hearing session 1, planning policy matters? Right. If you just give me a few moments to get the notes for hearing session 2 together. How are we doing for time? Okay, we're all right. So I take it we're sticking with the same team leaders. What I would just say is that I really do not want to spend this session debating the respective housing land supply methodologies. I want you to believe me when I tell you this is not the first time that parties have talked to me about the respective methodologies over many years of my planning career. But what I have done is developed some very focused questions which I wanted to discuss with the parties, which I thought I needed to understand in order for me to determine this case. Can I just warn Mr. Hogg now that if you thought the previous session was geeky, then this gets really seriously anarchy, or potentially can. So I'll touch base with you before we move on to various sections, but I just warn you. So if we can start on item 2A, and if I can start with the council. In the general case, leaving aside this particular appeal, just in the general case, what is the policy purpose of a 5-year housing land requirement as set out in the development plan and SPP?
So I think it is quite simple. It's for the proper planning of the area and to ensure that the housing needs in that area are met, and that the residents of West Lothian and the wider area have an equal opportunity to housing of a quality and standard that we would expect.
Okay. Sometimes when I've asked this question at similar appeal sessions, people have added to me things like, because of the lead-in times, that you need to have a forward supply. Would there be other things that is the planning purpose for a 5-year requirement?
Yeah, I think so. They could be reasonable considerations. It does seem to me that the principal purpose is about meeting the demand for housing in West Lothian. We will come into some more detailed discussion, no doubt. There are factors out there at the moment in terms of labour shortages, in terms of delivering housing. We're seeing more and more challenges there. We're seeing more and more challenges about the cost of materials. We are hearing some evidence, sir, of some programmes or projects being held over for the moment, just because of the uncertainty in these matters. I suppose, sir, a 5-year effective supply gives at least a chance of levelling out those peaks and troughs in the market. But sir, the council's clear position is that there's oodles of land out there for delivering housing in West Lothian, and the reason that that's not being built is because there is no demand for that housing. I don't mean, sir, that there is no demand, full stop. That there is no demand for 2,000 houses or 2,500 houses being built every year in West Lothian, which is what the appellant's figures would suggest that we have to do. The demand for housing is 700 or 800 houses per annum in West Lothian, and that is the number of houses that are being built.
Okay, for the appellants, I'll let you come back to what the council said there, but just in terms of my initial question, in your view, what's the policy purpose for a 5-year housing land requirement as set out in the development plan and SPP?
Okay. What SPP? Just to be clear, sir, SPP and the development plan don't ask you to maintain a 5-year housing land requirement. They ask you to meet your housing land requirement over the development plan period. That is what is being asked by both SPP and the development plan asks for the housing supply target, but we can assume that because of the changes to SPP, that overrides the development plan, but we can discuss that. So what SPP and the development plan ask you to do is deliver a fixed, static, immutable number of homes over a period, which in the case of West Lothian and SENS plan is 2009 to 2024. The housing supply target to be delivered is 18,010 homes. The housing land requirement to be delivered is 19,811 homes. So that's the purpose of the policy, is to build that number of homes. Where it is identified through a monitoring exercise, I'm counting towards that number, that there is likely to be a housing shortfall. The policy response to that is policy 7 of SES plan, how to of the LDP, or the presumption in favour of sustainable development as set out in SPP. So That has to include housing completions. That is part of the housing supply target and housing land requirement. That has to include the effective housing land supply. Now, the effective housing land supply is that which parties have considered as free of constraints and available for delivery, not more than a 5-year period. The effective housing land supply is year 1, year 2, year 3, year 4, or year 5. It just can't go beyond year 5. That is the effective housing land supply. So through doing this exercise, this monitoring, counting exercise to test whether your housing land requirement has been or is likely to be met, if you identify there's a housing shortage, that is the policy responses, policy 7, policy how to, and the presumption in favour of sustainable development.
Okay, I noted that. Right, well, let's go around again. Mr. McCausland, any points you want to make?
Yes, thank you, sir. On the appellant's position there is that the requirement is, as I'm understanding it, not the effective 5-year land supply, but delivering the housing supply targets. So I'll refer you to paragraph 125 of SPP, and that does a number of things, sir. If I can just get it up, excuse me. Yeah, so paragraph 125, and this to me, sir, is the key, because if there's a failure in 125, that's what triggers all the other processes that we are talking about, presumption in favour of sustainability, etc., etc. But what 125 talks about is the effective 5-year land supply, not the land supply targets. It's the effective 5-year land supply. So the next 5 years is the important part. But you know what that says before you even get to that point is that the approach has to be flexible and realistic. I have seen no flexibility on the industry's approach to changes in current circumstances. They continue to promote the same position, which is it says so in the SDP, so it must be right. And I don't see that as being in any way realistic. And sir, you can look at the Scottish ministers to see whether they see that approach as being realistic. The ministers in promoting changes to SPP have identified that the pandemic is affecting delivery. It's identified other factors which are affecting delivery. So to continually rely on a single approach, which has been successful in the past, but what the minister, or an approach which the ministers has accepted is not appropriate to the current circumstances, does not deliver a flexible and realistic approach. Sir, the council's position is that you should adopt that flexible and realistic approach and assess the land supply against what the real demand for housing is, rather than something which predates the economic slowdown and the pandemic. Thank you, sir.
Okay, I'm going to let the appellants have the last say on that before we move on, but remind them of my point at the very beginning, is that I'm going to keep a very tight leash on this hearing session. I don't want us to just go round and round in circles about methodologies which I both understand you won't agree about. So the appellant, any final points you'd like to make from what you've just heard?
The point of taking a 5-year effective housing land supply is to achieve an objective. There is a figure you are counting towards, sir. I think that's the real point. What the figure that the council is seeking to persuade you to count towards doesn't exist in the development plan and doesn't exist in Scottish planning policy. It is asking you to count towards a different number that doesn't exist. That's why that methodology is not appropriate, because it doesn't answer the question posed. Paragraph. So if we refer, do we need to refer to the Court of Session judgment, sir?
If you feel I need to, I have read it extensively, and it's been referred to me. Which court session do you mean, Gladman 2?
Gladman 2,
Uh-huh.
paragraph 50.
Mm-hmm.
So SPP paragraph 115 states that development plan should address the supply of land for housing. They are required to set out the housing supply target for each area. This is a number of homes which the planning authority has determined will be delivered over the period of the development plan. It represents demand for a particular market sector. This number is to be increased by 10 to 20% in order to ensure a generous supply of housing. It is this augmented figure which represents the housing land requirement. When SPP is referring to the shortage in the effective housing land supply, it is to that figure identified in the development plan as increased by the percentage selected, i.e. the housing land requirement. So the council has to adopt the 19,811 home figure in terms of SPP to determine whether it cannot change that figure, which is what the council methodology does. It cannot attempt to do a different calculation. That's this annual average method doesn't accord. I'm trying to answer a different question, sir.
Right. Okay. I'm going to move on, because the reason I structured this session as as I have was because I'm completely aware of the differences between you, and I want to explore that in the way that I think is going to be helpful to me. So I'm going to move on to the next point and ask the appellant a question. Can you have a 5-year requirement when there's only 2.5 years of the plan left to run?
You can establish whether you have a shortfall in your housing land supply against the housing land requirement. You do not need to have a 5-year requirement, sir. What you're being asked to establish is whether there is a housing shortage against your housing land requirement. This 5-year requirement, there's nothing in SPP or the SDP that says when you have less than 5 years of your development plan remaining, you do not need to address the issue identified. There is nothing in SPP or the LDP or the or any document that says you don't address your shortage. You monitor your land supply, you establish whether there's a housing shortage. In other terms, sir, maintaining a 5-year effective housing land supply at all times. That is what that means.
Mm-hmm. Okay, can I just think about that? So if I was to say what you're saying to me is that when SPP and the development plan refers to 5 years, that's a means to an end, not an end in itself. And the key point is whether there's a shortfall against the plan requirement. Have I picked that up right? That's your point?
Maintaining a 5-year effective housing land supply at all times is a monitoring exercise to determine whether the appropriate policy response is required. And the objective of that monitoring exercise is to establish whether the housing land requirement will be met. Where it's unlikely to do so, you do the appropriate policy response. Where it appears that you will, that's okay. You don't have to do the appropriate policy response.
Okay, thank you. Council, any thoughts or comments on what you've just heard?
Yeah, sir. So I will reiterate the council's position that irrespective of land supply targets or figures set out in the development plan, the requirements of SPP to the council are very clear in terms of paragraphs 123 to 125. They are the paragraphs that deal with the effective 5-year land supply, which is the test for other processes to come into play. It's where there is a deficiency in the 5-year land supply that the process has the opportunity to look at matters such as sustainability. The council points to paragraph 123 and 125. However, the question, sir, is can you have a 5-year land supply when you don't have 5 years in the development plan? I think it's a very challenging position. I don't think, for example, that you can simply roll forward the land requirements of the SDP because that doesn't adopt the realistic and flexible approach required by paragraph 125 of SPP. So I think if you have to do that, sir, you have to look at other evidence about what the demand for housing is, and we've already set that out from the council's position, Chair. I won't repeat it. Sir, from the council's position, it's Honda 2 and NP F4 as emerging. Sir, if you have to answer this question clearly, I want from the council's perspective to advise you on how you should do that. One of the things that you might do in doing that is look at paragraph 34 of SPP, which says, and I'm paraphrasing, if this gets a wee bit too difficult and there's an emerging plan that will give you some of this evidence, then you might want to treat the application as premature until you have that evidence before you. Sir, it is absolutely clear to the council that the land supply, the land requirement figures that will come out of that process are significantly different to the current figures which you are being invited to adopt in terms of the calculation. That, sir, in my view and the council's view, is not the correct approach in a plan-led system.
Okay, let's just move on. If I can go to the appellant, we've kind of touched upon this. In the general case, are there any policy implications if the overall housing land requirement seems unrealistic to attain?
I don't think it's unrealistic to obtain, sir. No, there aren't. So there are no policy implications. If it's you have to invoke policy 7, and you have to invoke policy how to, and you have to take account of the presumption in favour of sustainable development, and in that process, you have to determine whether there are any housing shortage that emerges needs to be addressed. That's clear from the court decision. So,
but there's degrees of addressing, isn't there? One of your criticisms of the council's average method is that it wouldn't achieve the housing land requirement.
yes.
But adopting your method, there's no guarantee adopting your method that we'll actually see 19,000 houses built in 2024 either. So does there come a point where you have to say, well, I need to write this off?
No. The point of where you write that off is when the next housing land requirement is identified. through the development plan process. If the council was not happy with its housing land requirement, it should have undertaken a new development plan and sought to address a different number and a different method. That the development plan still sets the housing land requirement. That is the figure that is to be achieved. That's only when a new plan comes into force, it is adopted or approved, is the point where you reset the figure.
Okay, thank you. For the council, any thoughts or comments on what you heard there?
Yes, sir. Clearly, the figure is unrealistic to attain. At the peak of the housing market, sir, the completions in West Lothian were around 1,200 houses per annum. The suggestion that we can now have 2,000 houses completed per annum is just not realistic from the council's perspective. And sir, I'll give you a very sound reason for why that's not realistic, because the reality is that there are houses and sites capable of being delivered today for housing. There's no infrastructure constraints. There are no other constraints on these housing sites, but the market is opting not to deliver it. So, sir, I would turn the question back to yourself and ask you to question why the market is not delivering those houses. And that example, sir, is that much of the council's land supply, although not all, but much of it is focused on core development areas. The council has worked long and hard to remove the infrastructure constraints on those housing sites. At Winchborough, for example, we are now investing £65 million on school infrastructure to remove the remaining constraint on development at Winchborough. There are houses sitting there with consent for, or sites with consent for 3,500 houses. There is no reason why, if there was a demand for 2,000 houses to be built next year, sir, that 2,000 of those couldn't be built in Winchborough. So, I would ask you, sir, to question why the market is not delivering in that way. And of course, it's not just Winchborough, it's the other core development areas at Calderwood, where just over the last month, we've opened the new primary school at Calderwood, which removes the principal constraint on development at Calderwood. 2,500 houses with consent there. Why are those houses not being delivered at this point in time? I know the answer, sir, and I hope that you know the answer. But to conclude on this, I'll go back to what the Scottish ministers set out when they identified that this process had to change because it was a failing process. As I say, we know what happened with that process through the courts, and there was no change to SPP. However, it doesn't change the principle of why the ministers were promoting that. And at paragraph 7 of the consultation, they set out 4 bullet points as to why things had to change. Excuse me. The first one is that it had to be a plan-led approach to decision making. They talked about removing the presumption in favour of development. Well, we know where that got to. Third bullet point is providing a clearer basis for decisions. But most importantly, sir, I would draw you to the 4th bullet point in paragraph 7, where it says that what they needed to do was clarify what is meant by a 5-year effective housing land supply, and in particular, preventing sites that are capable of becoming effective being excluded solely on the basis of programming assumptions. So if you take that bullet point at its intention, as I read it, then every one of those houses in the core development areas in West Lothian are effective housing sites. And it's simply because the industry is not programming them for development that they do not feature in the calculation. That, sir, is not the correct approach.
Okay. Okay, Appellant, we'll just go around again. Appellant, any concluding marks?
Yeah. So I think the council, I mean, it's not relevant anymore because PAN 1 of 2020 and the final estimates are quashed. But fundamentally, sir, the decision making, I think the council got it wrong in how it was to apply the finalised amendments and PAN 1 of 2020. I'm happy to discuss that.
If you're telling me it's quashed, then I'm
Happy with that. That's fine.
that-
Okay.
we can. Okay. Have we done?
Well, one more point, sir. I would like to say the council, as referred to earlier on, the SDP sets out a paragraph 3.12, the counting mechanism to be undertaken of the supplementary guidance, and that is the residual methodology, or what is termed the residual methodology. It would be interesting to be aware to understand, given that SPP and the finalised happened in 2020. Has the council, this is just a general query, has the council itself invoked policy 7 of SENSPLAN and policy how to of its LDP in the period since September 2017, when it was well aware that its housing supply target was not going to be met? That is its development plan. The council is very keen on the primacy of the development plan, yet is ignoring its development plan or what it is needing to do. And I think I just would like to understand, because I don't think they have, and they should have. I'm just trying to understand whether they did.
Yeah, I'm focused on this particular proposal rather than going back over what happened at the LDP examination. Can I just move on to go through some of my points? And I think actually I had a question under 2D, but actually in our discussion you've answered that, so I'm very happy that I know where you're coming from there. So if we can move on to item 3 and 3A and start with the council. Perhaps you can just give me a little bit of background and explain the process you go through when you undertake a housing land audit, particularly the 2020 housing land audit.
Yeah, thank you, sir. Happy to do that. I might ask Mr. Lovell to give me a wee hand on this if I stray off, because Steve is much closer to it than I am. But in essence, sir, we take the known housing sites, and we'll generally use the previous year's audit as the starting point for that. We'll have a trawl to see whether there has been any material changes to that. So, sites being used for non-residential purposes, for example, or indeed any additional sites coming forward. So sites that have been granted planning permission in the interim. So we would update. I'm going to stop, sir, because you've.
Hello, can you hear me?
Yeah, I think we lost you there.
Yeah, right. I'm not sure whether you lost me or I lost you, but
Well,
you got as far as saying before you froze that you did a trawl.
yeah, we do a trawl to see whether any sites have come out of the supply through being used for alternative purposes, non-residential purposes. And the second element of the trawl is sites coming in to the audit through the granting of planning consent or other related processes. We will then have an assessment of the likely delivery programme for each of those sites. And again, that will be informed partly by the previous audit. And then there is a round of engagement with the house building industry to, if you will, sort of test the assumptions that the council has put forward in terms of that audit. The end of that process, we aim to have an agreed position with the house building industry. That's not always the case. There are, in some instances, where we can't quite agree whether a site is effective, or we can't quite agree the programming of that site. But that tends to be, I would say, sir, at the margins, and we've been pretty successful in working with the industry to get agreement on the audit.
I wonder if the appellant's team can actually hear me, and whether they heard Mr. McCorrison's answer there.
Yes, and Mr. McCorrison's answer there. I've no disagreement about how the housing land audit is prepared. So.
Okay, so that's helpful. And then, based on our discussions so far this morning, I might just tweak my question here. But for the appellant, in your submissions, I noticed you had one or two reservations about the 2020 housing land audit, but nonetheless, is it something I can still rely upon?
Yes, sir. You will form your own judgment, sir, whether those disputes are valid or not. Okay. Yes, sir.
And that's helpful. Can I now turn to C and ask the appellant, is any programming post 2024 relevant?
No. That's what the law says.
Okay. And the council, would they agree with that?
So we would take the opposite view, I suppose, for the reasons which I've set out previously. I don't think you can simply ignore the land which is available for building of housing just because it's out with the 5-year period. I do accept that the 5-year land supply calculation looks at that 5-year period, but clearly the Scottish ministers, in their view, is that just because a site is programmed beyond the 5 years because the industry can't deliver that site, shouldn't mean that the council and communities are disadvantaged by that process simply because housing cannot be brought forward quick enough by the industry, or indeed, so that there is no demand for that housing, or no demand for that housing beyond that which has already been calculated. Okay,
thank you. I've noted that difference. Can I now go on to 3D and ask the appellant? You set out in your appeal submissions your expected programming for this site if planning permission was granted. Is that still your expectation?
Yes. And I think the council officer earlier on said that seems appropriate programming as well.
The second period, 68 a year, seems quite high. Is that because the affordable housing will be built by another party?
Yes, sir.
Okay. I noted the council's comments previously as challenging, but not necessarily unrealistic. Is there anything you'd like to add?
No, sir. I think we're okay on that position.
Okay, thank you. Right. And then finally, and hopefully we can deal with this quickly. On item 4, I included as an annex my understanding of the key parameters. And if I can just ask the appellants, do you accept the annual completion figures provided by the council, which I repeated in Annex A?
I understand the council and the appellant have got the same completion figures, which come to 7,300 and trying to find the. But yes, I believe the council figures and the appellant's figures are the same. Yes.
Okay, and so you're content with that I've correctly extracted the key parameters in Annex A?
Yes, other than the housing supply target being 18,010 homes, but that's just that's okay.
So wait, what should have that been? Have I made a mistake?
Just as I understand, so point 2, the housing supply target you've identified is 18,011.
Yeah.
I understand that it's 18,010. So I know, but I'm just yeah. So that's sorry.
Okay. Heaven forbid that we missed a house elf. Right. Mr. Hogg, again, I don't know what you you made of all that. Any comments?
Not at this stage, no. It's all a bit of a learning curve, but I'm learning lots, if I'm being honest.
Great.
I can buy an anorak on eBay if I need to.
Okay, thank you. Right, well, I think we've reached an appropriate time to take a break. So if we take our lunch break now and come back at 12:45. Oh, you're quite right, Mr. McCauston. I promised you a chance, and I was so keen to knock hearing session off that I forgot. I do apologise. Off you go.
So thank you for that. It was actually 2 points. You didn't invite the council in just in terms of the accuracy of Annex A. We are happy to confirm that you've represented the council's figures correctly. I would make 1 point, however, on that. So just to remind everybody that those are all tenure figures, and that the significance of that in terms of the 18, 19, 19, 20 figures is that that was essentially the climax of the council's house building programme. So a very significant number of those completions are actually not completions by the private sector, they're completions by the council. In fact, the council over that period was by far the biggest house builder in West Lothian. So it was just to remind yourself that there are different components of the market there, and of those 1,107, a significant amount are from the council. So the other issue was in relation to the local plan examination. I'm not going to go very far with this, sir, because I think you've set out the position fairly clearly in terms of what the considerations are. I would wish to just, however, pick up on the issue about the reporter at the local plan examination. Although the reporter there found some challenges with the land supply in West Lothian, I would remind you, sir, that actually in doing so, the reporter took some sites out of the LDP. He did put some sites in as well, to be fair, but he actually took more houses out of the land supply than he put in through those changes. So clearly, sir, he wasn't so bothered about the land supply that he was prepared to allow any site at any cost. I should say they, sir, because there were more than one reporter, but they clearly had a consideration about a number of factors of the sites, including their sustainability and emerging positions in terms of how they might calculate the land supply, and wasn't so bothered that he was prepared to allow every site to go forward. And of course, this site was a consideration as part of that. But in finding a deficiency in the land supply, they weren't prepared to allow this site to be part of the LDP position. Thank you, sir.
Right, for the appellants, any thoughts or comments just to wrap up?
The council, the reporter was obviously that concerned about the housing land supply position. They modified policy how to address the shortfall. So he was quite concerned about that. I don't think you could put it. Mr. Bottom wasn't concerned about that. Whether he took sites in or out, that's up to those sites that were before them. But the council selected all those sites. It's the council's got to take ownership and accountability for its plan. That's what the council has to do. So whether sites were in or out, and then that's what the reporters decided. Whether this site should have been put in or not, that's reporters assumed there wasn't enough evidence to support it because it wasn't in. So there's no harm in coming back in through policy how to test and assess it. So that's where we are today. So.
Okay, thank you for that. Right, I think we've got to the end of session 2. What I'm suggesting is that we take our break now, and we'll rejoin at 1:45 with hearing session 3. Can I advise parties it's best if you could just mute and turn off your video rather than logging off? Otherwise, we'll have all the usual problems of everyone trying to log on again, and that will waste time. So I'll see you back at 12:45. Okay, is everyone back who needs to be back? I get very nervous when my screen just goes blank like that. Can everyone hear me? Yes?
Yeah, so we can hear you, but we can't see you.
Right. Okay. Well, that might not be fatal. Is everyone back who needs to be back?
Lee, can I just check that
Certainly
you're
from the
there?
council side, sir, that's the case.
Okay. For the appellants?
Checking if Lee's there.
Yes, I am here, but my screen seems to have frozen.
It's okay.
Right. Let's bash boldly on and hope the technical difficulties sort themselves out. Visual's not quite so important as being able to hear. So we're back at session 3. The objective for this session is that the appellant had submitted 4 key documents justifying their proposal. So I'm very clear of their position. I'm less clear of the council's position in response to those. And I had some detailed questions about siting and design. So if we can start at item 2, if I can start with the council. Do you have any issue with the methodology employed in the submitted landscape and visual impact assessment?
So on this session from the council's perspective, I'll ask Marlon Fatua to lead on the council's response.
Thank you, Susan. The council does not dispute the methodologies used, put as simply as that. But however, obviously the position on the actual conclusions was set out in the hearing statement and also in the appeal documents submitted with the planning authority response. But we do make a note that these documents weren't in front of the council when they were making the decision on the planning application. We do note the conclusions, but however, our main point on all 4 documents is that the proposed development, while trying to address the issues of the concerns on the previous application and the appeal decision, the revised area of housing does not overcome those concerns on landscape impact, character, sustainability, and obviously the concerns reflected in the previous appeals decision.
Okay.
Thank you.
Thank you. Yes. I know all 4 are closely interrelated, but I'm going to try and break them down and look at each one in turn. The appellant, any thoughts or comments on that? I take it you heard the answer there.
Yes, yes, I did. I don't have anything else to say in that regard.
Okay, thank you. And on the an agenda, I apologise. I made a mistake. 2B related to defensible edges. That really should be in the countryside belt assessment, item 4. So I will cut and paste that point and relocate it to item 4. Anything else we need to discuss about the submitted landscape and visual impact assessment? People will have to shout if I can't see them, but I'm assuming that's a no. So if we move on to item 3, the submitted settlement and local character assessment, and if I could start with the council. In the council's view, would the character of Hens Nest Road change? And if so, how?
Well, yes, it's simply that the Hens Nest Road, south of Hamilton Way, as you say, where the site is developed, that will significantly change the character, in our opinion, from on the road users and the local residents along there, where the outlook is onto countryside, and which it forms part of the countryside belt, which is part of the settlement character of East Whitburn. Yeah, that's...
Okay. Mr. Hogg, have you got any views on this?
I'm fine here. Sorry, just listening in.
Okay, thank you. The appellants, any thoughts or comments on what you've just heard?
Well, if I can draw your attention to the figure on page 12 of OH4, the settlement local character assessment. Our analysis shows really that the other side of Hens Nest Road, opposite the site, is actually quite an urban frontage to a street. It's quite similar in character to the rest of Hens Nest Road as you travel north into the settlement. Whereas to the south of the site, as you pass over the burn, the sort of eastern side of Hens Nest Road has actually got quite a significant tree belt planted along it, which is more of a kind of countryside edge. And I'd invite you to inspect the difference between these two boundaries. Site visit tomorrow. So the urbanizing of the site, the appeal site, would really bring that stretch of Hens Nest Road more into keeping with the Hens Nest Road character further to the north of the site, and actually the experience of entering the settlement would remain broadly similar, i.e. it's quite a countryside feel to both sides of the road to the south of the site, and then it would be urban. Admitted there are views over the site currently. However, this isn't necessarily pristine rural pasture. There is already a building constructed in the middle of it. There's demolitions, and as I say, the other side of the road is urban in character and has no sort of scope for its reduction in urban character in time.
Okay. Thank you. Council, do you want to come back on any of those?
Yeah, sorry. It's Martin. Yeah, the position's noted, but however, we simply disagree that the character of Hens Nest Road will be significantly changed.
Okay, Mr. Hogg, anything to add?
No, I'm fine with that. Thanks very much. Sorry.
Okay.
So can I perhaps add something which might provide a wee bit of background that might be helpful?
Provided it is helpful.
Hopefully. I think it's self-evident that the original settlement of East Whitburn has been allowed to expand over the years, and it's been supplemented with elements of new housing. And while there are certainly legitimate and differing opinions on how successful this has been over in terms of visual integration, The key point is that it's been managed, changed and planned growth. And it's always been proportionate to what the infrastructure and the environment capacity could comfortably absorb. And it's always been the council's intention to safeguard and protect and maintain the physical integrity of the village and critically avoid coalescence. The history of this site, the appeal site was actually an important piece of that protective strategy because it was originally part of East Whitburn's Mains farm. And back in 1984, it became part of a pioneering lowland crofting initiative. And that was an attempt to improve landscape and bolster natural heritage and help revive the local rural economy. And at the same time, trying to harness some emergent demand for rural living. So the concept was to repurpose these farms with poorer quality agricultural land, and the trade-off was to allow some element of mainstream development, and that's what you see on part of HENS Road at Hamilton Way, where there are 15, I think it's 15 housing plots. But there's also a number of lowland crofts or small holdings which were created on the balance of East Whitburn Main Farm. And the appeal site itself, part of it, was granted permission for a modest house and an outbuilding to operate an equestrian centre. Now that was up and running for a period of time. Unfortunately, that commercially failed, and over time the ancillary buildings have been taken away. But I think the key takeaway from this is that the west side of Hens Nest Road has long been regarded as visually sensitive, and there's clear evidence of the council having sought to safeguard this land from inappropriate development for quite a long period of time. And I think it would be regrettable if the appeal proposals were to be consented, which would undo this long-term strategy.
Okay, I've noted your differences. Can I move on to B then? And if I can start with the council, if the proposal was constructed, what changes to the character of East Whitburn would you predict as opposed to the road?
Certainly this site is quite remote from the centre of the settlement, albeit there is existing development on the eastern side. It will have an impact on the settlement and the character and the visual amenity looking south from south point of Hamilton Way, and that's simply our position on this.
Okay, thank you. Appellant, any comments on that?
I'd just say that the settlement and local character assessment concludes that the proposal is in keeping with its surrounding character, and that no changes are expected to the character of the settlement assessed in paragraphs 4.29 to 4.44, concluded in paragraphs 5.2 to 5.4.
Okay, thank you. And if I can just go back to the appellants, the impact on the character of the locality and settlement was referred to in the previous appeal decision. What is different about the proposals before me?
The previous proposal resulted in about 3.3 hectares of open fields being retained between East Whitburn and Whitburn to the west, and no fields being retained between East Whitburn and Bickerton Crofts to the south. The current proposal retains about 9 hectares of open fields between East Whitburn and Whitburn, and 6.3 hectares of open fields to the south between it and Bickerton Cross. This is a significant increase in open space, and previously the approach to the settlement would go past open fields before arriving at the settlement, whereas the previous proposal resulted in the infilling of the field to the south of the site. So really going from woodland to the settlement. So we're retaining here a buffer of open fields between East Whitburn and the surrounding settlements.
Okay, Council, any thoughts or comments on that?
Our position, it's our opinion that while there has been changes, it simply doesn't overcome our position. It's set out in our response, also addressing issues of the previous appeal decision in terms of coalescence and character.
Okay, anything from Mr. Hogg?
Yeah, I suppose I'm still struggling as to why we still want to build on pastoral agricultural land. I think it would change the infrastructure between East Whitburn and Whitburn immensely. I still maintain that Hens Nest Road at its widest point at 14, 15 feet just cannot cope with the extra load in terms of traffic and congestion, and the infrastructure alone is not going to be able to sustain this.
Okay, thank you. Anything else we need to discuss about the settlement and local character assessment? I'm not hearing anything, so I take that as a
Sorry,
yes.
just one more point. In terms of the quality of the character of the open fields between Whitburn and East Whitburn, at the moment there is quite an extensive urban edge to East Whitburn. So the development to the north of the site has an urban westerly edge and a southern edge, and the extent of the development to the eastern side of Hens Nest Road opposite the site is urban, and these edges will continue to be urban. There's no tree planting or anything which can mature. What the site, the proposal is includes tree planting and open space around its western and southern peripheries. And so in time, the idea of this is to reduce the urban influence of East Whitburn on the remaining open fields between East Whitburn and Whitburn. So in the long term, this is providing a boundary which will enhance the quality of the remaining open space, albeit a slightly reduced amount of open space. But we're reducing the urban influence of East Whitburn on the surrounding open space.
Okay, thank you. Have we done with item 3? Can we turn now to item 4? And this is the countryside belt assessment. And if I can start with the council, how useful are percentages of areas and dimensions in determining coalescence?
Measuring the dimensions, the distances, the square, it's useful in a way, but however, in terms of coalescence, it goes back to the policies that in terms of the protection of the green belt and the impact on that, whether the distance is if it's close or not, it's the impact on the green belt as a whole that's more important to our assessment.
Okay, appellant, any thoughts or comments?
Thank you. Yes, I point out that the countryside belt is really designated to keep a buffer and a separation between neighbouring settlements, which it is doing. But the existing distance between East Whitburn and Whitburn, the urban areas anyway, is about 180 metres, and that is between Hamilton Way to the north of the site and Whitburn. There's an urban edge to East Whitburn, some open fields and some woodland. The proposed distance between the proposal and Whitburn is 318 metres and includes tree planting. That's 138 metres further away than the recently developed way proposal to the north. So we're in no way reducing the gap between the two settlements, and there's a similar situation to the south of the site, where the existing development to the east of Nest Road is 215 metres away from Bickerton Croft, and the current proposal is 292 metres away. So we're still maintaining this decent buffer. It's quite a sort of equal buffer, and I think the countryside belt remains very much in place. And I would just say again that the boundary of that countryside belt will be enhanced compared to the existing.
Okay, I've noted that. If we can move on to the next one, if I can ask the council, if the proposal was constructed, would coalescence be perceived between Whitburn and East Whitburn, and by whom?
Yes, the nature of the built settlement already predominant on the eastern side of HENS Nest Road. So we go back to the character of HENS Nest Road, which is a significant change itself. So there's perception within HENS Nest Road itself, where that urban edge goes out onto the countryside belt. Also in terms of the path users in between the open space networks, this will be a significant visual change to East Whitburn when you're using the paths, and that could lead between the lesser of that distance between the settlements when you're within that buffer itself.
Okay, Mr. Hock, would you like to add anything?
Not greatly. I still maintain that the road itself will not be able to deal with the extra demands on it in terms of traffic and or local infrastructure in terms of the residents.
Appellants, any thoughts or comments on that?
Firstly, just to come back on the experience of coalescence from HENS Nest Road, arguably the experience of coalescence as experience on HENS Nest Road would be from sort of a separate settlement coming towards it. It's not a coalescence if you have development of the same settlement. Secondly, I think it's clear that probably the only place that coalescence could be perceived from is the local path network, as pointed out. I can draw your attention to the landscape and visual impact assessment, so H5. Oh, sorry, no, it's not. It's H3. And one viewpoint in particular has been selected to assess the advancement of East Whitburn towards Whitburn, or the path which is between the two settlements. If you look at figure 07B, you can see the view from the path towards East Whitburn and the view across the site. And from here you can see the urban edge of East Whitburn quite clearly. If you move on to the next figure, 07C, you can see that there is an urbanizing effect in the short term of the proposal. It does bring development closer to the viewer, although there's still a gap of open fields. But then if you advance to the next figure, 07D, this shows the effect of the tree planting after approximately 15 years. So you can see the difference between 07D and 07B is that there's a net reduction in the urbanization of the space between the two settlements. This doesn't look like the merging of two settlements. This looks like a clear boundary of the existing settlement. The tree belt that's proposed to the western edge of the proposal is actually very similar in nature to the tree belt that is existing on the western edge of the site, just to the southeast of the site, on the other eastern side of HENS Road. And I'd invite the reporter herself to inspect this boundary tomorrow, just to see how appropriate that is as an edge to the countryside belt, as opposed to the eastern side of HENS Road opposite the
I've already been on site, not on the site, but walked around all the pathways on an unaccompanied basis. But we can discuss about that later on. The council, any comments in response to that?
No, sir.
Okay, if I can move to my relocated bullet point and start with the appellant. How does the proposed planting in tree belt that we've just talked about create a more defensible edge compared to the current road?
I think I've touched on this just now, but I think the tree planting to the western edge, the open space and tree planting to the southern edge, does create quite a strong boundary, a rural edge to the settlements, an appropriate long-term boundary to the settlement. It will take a few years to establish, but we're looking here at the long-term improvement of the quality of the open space between WHITBURN and East WHITBURN.
But how's that different from the road at the moment, which has been a boundary for many years?
It's different because the current housing on the eastern side of the site is an urban influence on the character of the remaining open space between these two settlements. It has an urbanizing effect, as shown on existing photo 07B. This urbanizing effect will be there forevermore. As there's no tree planting there, it'll stay urban. So what the proposal does in the long term is enhance the quality of the remaining open space between these two settlements.
Council, any thoughts or comments on that?
In terms of where it creates a more defensible edge than the current, the council's answer is simply no. The current road serves as a more defensible edge if you were encroaching into that landscape out. Yeah, and as you said, it's been set for a number of years, and it's yeah. So, thanks.
Okay, thank you. And moving on to 4C, again, starting with the appellant, the previous appeal decision referred to coalescence. Again, what would you draw my attention to, which is different about this proposal?
I'd say that the previous proposal would have extended the urban development approximately 100 meters closer to WHITBURN to the west. And it would have infilled much of the remaining field with woodland planting. And so the extent of open fields between the two settlements would have been dramatically reduced. This feeling of having open fields. So the current proposal retains a much clearer rural buffer between the two settlements than the previous proposal. It also would have extended urban development approximately 240 metres closer to Bicton Cross to the south. Would have removed the field to the south of the site completely from this area. So the current proposal also retains a much clearer rural buffer between these two settlements.
Okay, thank you. Council, any thoughts or comments on that?
So maybe I'll just say a couple of comments here. I mean, I think it's quite clear from the previous reporter's decision, which we've all read in the relevant paragraphs. Again, I'm sure the previous reporter shared the council's concerns in relation to the whole of the land between HENS Road and Whitburn itself. The council doesn't accept that by extending housing further westwards from HENS Road benefits the situation. The extent of housing proposed in this new proposal is slightly further east than was previously proposed. However, overall, the quantum of the westward incursion from HENS Road is very similar. The proposal includes a tree belt of some about 8 metres wide, and the appellant has us believe that that essentially solves all evils. Again, that backs against people's back gardens. So essentially, you could have a hedgerow mix. The acceptability of large tree species there would have to very much be aware of. They could potentially cause huge overshadowing of those west-facing back gardens. And we have lots of experience of fairly narrow tree belts of this kind of nature, and a lot of cases for residents they can raise substantial nuisance issues. So a tree belt starting on someone's back fence of that width, the council would certainly question the suitability of that. The proposal doesn't involve any planting along the western boundary of the properties on Hamilton's Way. Again, you read the appeal reporter's previously decision, where essentially she said that the existing housing at Hamilton Way was a bit of an outlier. It's not assimilated into the landscape, and essentially it's a bit of a sore thumb down there, and that the character of East Whitburn is quite clearly HENS Road, forming a defensible boundary there. So, I think in terms of the distinction with the previous proposal, in an east-west, from east-west distinction in terms of the width of the tree belt, we're seeing a similar proposal and a similar incursion. Yes, it doesn't extend southwards, and again, but again, the extent of any suitable planting along the southern boundary. Well, we have plots in the southern boundary, probably only a couple of metres or so off the southern boundary. So again, I think it's the council's view that the scope for mitigation planting essentially along the southern and western boundaries is substantially overstated by the appellant, and I don't think it addresses the previous concerns of the council or indeed of the appeal reporter, and it's as simple as that.
Okay, I don't think you're going to agree on that. Is there anything else we need to discuss about the countryside belt assessment? Oh, I should have said, Mr. Hogg, did you want to add anything?
No, I'm in complete agreement with Mr. Irvin's comments. I think that previous reporters' findings are still being ignored in the current application.
Okay, thank you. Can we now turn on to item 5? And we I have some questions about the tree belt in item 6, so we'll come back to that. In terms of, I'd like to start with the council. In terms of the submissions before me, the appellant in table 3.1 of OH6, and this in turn is expanded in the appellant's response to the council's appeal statement, goes through the SPP para 29 issues in some detail, and I wondered which elements of that assessment in table 3.1 the council would take issue with.
So if I maybe question on reply on that matter. I think in general terms against the SPP criteria for sustainable development, that's what we're talking about here. I think in terms of essentially, it's hard not to hark back the previous appeal decision, but really find them having to do so. I think the position remains the same, essentially where the appeal decision found that certain points of the criteria it would contribute to, such as construction activity, some open space provision. But again, the fundamental aspects about its impact on the countryside belt, the accessibility to services, overall, it means that it doesn't overall contribute to sustainable development. So, in terms of the assessment against the SPP criteria, the Council's position is that the previous findings of the appeal decision still hold water.
Okay, hang on a second. Just let me. Okay, appellant. I'm hearing some feedback, so if people are not speaking, if they could turn to mute. Appellant, any thoughts or comments on what you've just heard?
Thank you, sir. As you pointed out yourselves, the appellant's undertaken a detailed assessment against the 13 principles of sustainable development, as set out from paragraph 3.3 of OH6. I'd also just like to draw your attention, sir, to just the comments there from the Council on the accessibility of services. Appendix 1 of document OH6 provides a detailed map that identifies key services within East Whitburn and Whitburn and beyond. Just to pick up on a few of those, both non-denominational schools, that's Whitedale Primary School and Whitburn Academy, they're both within 1,600 metres of the site in accordance with Band 75. You also, in terms of active travel, have links to the core path network, which is shown on Appendix 1. There's also the cycle network as well, that again is set out in document OH6. So I think in terms of active travel, we're certainly ticking the boxes there as we set out in table 3.1.
Okay, I've noted that. Can I now go to 5B, a question for the council? In many of the representations before me are concerns about the lack of facilities, but particularly in relation to the lack of healthcare provision. What's the council's view on those representations as planning authority?
So I'll maybe answer those questions. Yeah, I mean, you see the council did consider those representations as part of the decision-making process. You'll note the council hasn't included those concerns as a reason for refusal. The council essentially notes that healthcare provision and and any new provision in relation to new development is explained through the LDP. That explains that responsibility essentially falls to NHS Lothian. And it provides the range of services provided. And delivery and implementation of any new provision is ultimately dependent on the NHS and other individual practices. The LDP does allocate land for new health centres, particularly in core development areas, and where appropriate, we do seek appropriate contributions. There's direct reference to that in LDP policy HEU7. In fact, the LDP also indicates that supplementary guidance will be prepared in relation to healthcare provision, but has unfortunately been delayed. At this point in time, the council position is there is a healthcare provision in Whitburn, and that would serve the development here, and the council isn't seeking anything further.
Mr. Hogg, any thoughts on that?
No, I have to agree with Mr. Irving again. I think that's 100% correct.
Appellants?
Thank you, sir. The only point I would like to make is that it's the Whitburn Group Medical Practice that covers the area for East Whitburn, and they're currently registering new patients. So it's the appellant's view that there's no adverse impact as a result of the development on the medical health practice.
Okay. Are there any other points we need to discuss about the Sustainable Development Assessment? Right, can we move on to item 6 then? And we'll start with 6A and the council. Your 12th, and we touched upon this morning, your 12th reason for refusal related to certain very detailed aspects of a road layout design. In the event that I was minded to grant planning permission, are these sort of details something that can be resolved?
I'll respond to this one, sir. Yes, you've noted the council did raise useful reason for refusal concerns in relation to the detailed layout. The council in its hearing statement has set out the particular matters. I mean, ultimately, there's a layout before you, that is the only layout before you that's being addressed here. The council has made comments on the deficiencies of that. Could they be resolved? Well, the council will have to see a revised plan. It would have to assess that, and then we'll be able to give an answer. At this point in time, there is no revised drawing on the table. We have the plan that's been refused. The council's position is there are deficiencies in that that make it unacceptable.
And what about the appellant's comment that this could be resolved by a planning condition?
Well, I don't think that's entirely appropriate in this case. The concerns are to do with the road layout in several locations. We're not talking about a couple of minor matters in relation to care positions and so on. It could leave if the appellant does change the layout, it may create other knock-on issues. Long and short of it is, any revised layout hasn't been considered by the council, and that remains the position. So, in short, I don't think it would be appropriate to deal with the numerous issues that would need to be resolved by a planning condition.
Okay, let's just look at my notes there. Again, if I could just come back to the council on that. Again, if I was minded to grant planning permission, would it be open to me if there was a notice of intention for the matter of amended plan to be agreed before I issued my final decision?
I think ultimately, sir, it would be a matter for you to come to judgment. We would have to see that drawing, but also have to take a view about whether it would merit any further neighbour notification. Again, hard to say unless we saw some kind of revised drawing.
In the council's experience, are these sort of changes not something that would be dealt with by a non-material variation?
Again, so I would say all a matter of fact and degree. I would think the changes that are needed certainly go beyond what we would consider to be non-material.
Okay, thank you. Appellant, any thoughts or comments on that?
Thank you, sir. I'd just like to draw your attention again to document PPA-400-2121, this correspondence issued by the Council on 2020 to the appellant during the determination of the application. That correspondence made clear that all these are capable of successful resolution in way of condition.
And what kind of wording of a condition would it be? Would it be something like, you know, a scheme to address the concerns set out in such and such to be submitted and approved?
Yes, I think that sounds okay.
Okay, we've explored that one. If we can move on to B, and for the appellant, you've provided a detailed maintenance schedule for the tree belt as part of your submissions. Perhaps you could just give me a bit more background as to how that would be practically delivered and funded.
Hello, can you hear me? Right.
Yep.
Yes, it would be, we would provide a management maintenance regime, and then through that, all the planting within the common areas would be maintained up until year one, and at the end of the rectification period by the appointed contractor. And thereafter, factoring arrangements would be put in place to maintain the common areas until the deed of condition. Now, there's, as part of the proposal, there are 3 access points from the proposed site, and there would be a proposed maintenance strip that would link from these access points along the edge of the structured planting that would allow for maintenance and access.
But who would actually own the land that the tree belt was on?
Could I get the lawyer or the Geddes to answer that for me, please?
Unfortunately, I'm a planning solicitor, not a property solicitor, so that is not my area. I could certainly address that matter in written submissions. So my understanding is that all these areas owners are granted a share in common, and then it's maintained by a factory arrangement through the deed of conditions, which applies to all the owners who own a share of it. But again, that's not my area of expertise, but we can certainly address that in closing submissions.
So, I mean, this isn't a particularly uncommon arrangement, but picking up some of the comments that were made by the council, what if all the future residents got together and said, we don't like this tree belt anymore? Would they be entitled to remove that and make it part of their gardens?
Again, as I say, I don't know, but I understand that that there would be a deed of conditions. I'm not sure how easy it is to overturn that, as it were, to alter it.
Okay, leaving the legal stuff aside, I mean, from the appellant's point of view, do you foresee any tensions between maintaining the tree belt and the attitudes of the house owners who back onto it?
Certainly, if there's factoring put in place and they are held to a specification and maintenance management regime, then there shouldn't be tensions. But that is something in the future that would have to be addressed, as we said, through deeds of conditions, and they would have a say if they weren't satisfied with the factoring contractor in place, whether they would be able to replace them if they weren't happy with the works that were ongoing.
Yeah, because typically under fracturing arrangement, each of the householder would pay a fee, and it's not uncommon for people who have to pay a fee not to like paying a fee and would rather pay less. So you know, could I'd come back to my question: could the householders over time, and you're telling me it's at least 15 years before it matures, could householders, for their own particular reasons, frustrate your design intention?
So we'll clarify that as part of the closing submissions. We'll speak to, but I think the intent would be that the deed of conditions would set out that belt's to be fitted. I think that's the point, and we'll clarify that for you.
Okay, council, any thoughts or comments on what you've just heard?
Thanks, sir. I've heard what we say. I would imagine that, I think as the appellants alluded to, the tree bill would probably end up being dealt with as part of the other common areas on the site, and would be dealt with under a deed of conditions or some other kind of development management scheme, registered against the land titles. But again, you know, I think all we can say is what we know in practice and what happens, not just in West Lothian, but probably across the board, where we have fairly narrow tree belts tight against back gardens. Particularly here, you know, we've got a southwest facing aspect. These plot owners, well, you know, no doubt one of the advantages of that is that you get the sun. The stated aim of the appellant here is to create a long-term defensible edge. Well, presumably we're going to see a lot of native broadleaf species. You know, that's the whole design intention here, and I see a clear conflict between that in such proximity to residential back gardens. And when you consider it not just in terms of daylighting, but there's nuisance value, there's leaf nuisance, there's not be direct overshadowing. So you know, we don't have a shelter belt of substantial width with a potentially an 8 metre buffer area from the back gardens. You have shelter built being 8 metres on the back gardens. So again, the council would just question the general appropriateness of that, which is clearly being put forward as a mitigating factor in favour of the development. But as I previously said, the council doesn't accept that it addresses the overall concerns of the council and of the previous appeal decision.
Okay, thank you. Is there anything else we need to discuss about the tree belt? Okay, if we can move on to C, and again, if I can start with the appellants. On the layout plan before me, there are a number of footpaths which just end at the red-lined boundary. What's the intention of that arrangement?
So the appellant owns the land to the west of the site, and the intention is to would be to link these footpaths on the outer side of the tree belt, so that they all can join together. This would give access to the countryside belt, so we could walk around the edge of the site. Basically link up around the edge of the site.
If that's the intention, would we not need to secure that by condition?
I think that could be secured by condition, yeah.
Okay, thank you. Let me just make a note. Council, any thoughts or comments on that?
Thanks, sir. I mean, the council has noted the 4 footpath connection points shown. It would give access to the surrounding countryside, but as you say, 3 to the north would just essentially link into a field at the moment. The council does note that at the southern footpath connection, there is an existing path slightly further west, but there would be a apparent missing section between those, so even that southern link wouldn't directly link into the existing path network. So the council no more than just notes the proposal. But again, we question really what it is actually achieving.
We may come back to that in hearing session 4, but is completing the missing link or links to the rest of the network something that could be secured by condition? I noticed it's within the blue line land.
Well, it's feasible, but the appellant doesn't actually show the site boundary of the footpath connecting with existing paths.
Okay, thank you. Anything else on footpath links? Okay, can we go on to 6D? And we touched upon this morning, and my recollection is, I'm going to start with the council. My recollection is when we were discussing the policy framework for open space provision, that the council said that the plan which is before me, in addition to active open space contributions, would comply with the policy framework. The appellants came back and said that the open space provision, active and passive, is more than adequate, and I think the implication was there was no need for an active open space provision. And there was a reference to a document which I'm afraid I didn't have and haven't seen. But can I start with, is that a fair summary of the position?
Thanks, sir. I'm not sure something's been lost in translation from the council side, but I think just to be clear, the appellant is showing adequate active open space provision on site, also showing adequate play area. So in short, the on-site provisions would meet the council's active open space requirements, and there would not be a need for financial contributions in addition to that.
It's amazing. It froze just at the most important part of your sentence there. I think you were about to say it's adequate and I don't need to worry about it, but perhaps you can tell me how you finished it all off.
Sorry, sir. Yes, adequate.
Yeah.
So no need for financial contributions in addition.
Thank you for that clarification. I trust the appellant is happy with that. Do we need to discuss any more on open space? Let's move on to F, traffic generation and parking provision during construction. Mr. Hogg, this is something that you've included in your hearing statement. I wondered if there was anything you wanted to expand upon today.
Not in a great deal. Obviously, I did put it down in my statement that the road as it is now is frequently blocked with farm vehicles and normal residential traffic. I just foresee this will be an absolute nightmare for the period of the construction or planned construction of this development. There's just nowhere else for tradesmen's vehicles to go, or distributing lorries or site plant to even get into the road, let alone pass through it successfully.
And for the council, can I ask, do you take any issue with the submitted TIA?
No, generally the council is content with the findings on that. And in terms of traffic generation and parking during construction, again, the council hasn't used that as a reason for refusal. You know, under council's draft conditions, as the council gives details of site compound and so on, we'd expect to see appropriate parking for contractors, and appropriate provision made for HGV deliveries on site.
Okay, appellants, any thoughts or comments?
Sorry, yes.
Thank you, sir. Yes, happy with the council's reference there to proposed condition 15 that they set out that there would be a requirement for the submission of location dimension of the site compound. Just to be clear, the appellant can confirm that all parking associated with the construction of proposal will be provided within said site compound, and that will be within the boundary of the site. The appellant's also willing to provide a standard detailed drawing which provides an example of a typical site compound used on existing development sites currently under construction, and again that drawing will demonstrate that all site parking will be contained within the appeal site.
So I didn't quite catch your beginning. Are you going to give me a typical drawing? Is that what you said?
Yes, sir, we'd be happy to provide that, yeah.
Okay, thank you. Okay, are there any other matters on that we need to discuss in hearing session 3? Have we done? Right. Let us move swiftly on to hearing session 4. We're making good time.
Sir, if possible, if I may just have a moment's break, if that's okay.
Yes, certainly. What are you talking about? 5-10 minutes?
5 minutes, if that's yes.
5 minutes. Okay, so let us all come back at 13:55.
Thank you.
Okay. Is everyone back who needs to be back? I'm not seeing the appellants team.
We are, well, we're all here, sir.
Good.
So,
Okay. And is the council team ready?
Indeed, sir, we're all here.
Good. Splendid. Right. We're on hearing session 4, planning obligations and conditions. There's a good measure of agreement between the parties on this. So it's really, for me, just to make sure I understand everything that I need to. So if we start at 2, I set out there the 3 bullet points where I think you are agreed that a planning obligation is necessary, and we've now just agreed that a contribution to open space is not necessary. If we go on to areas where I needed clarification on affordable housing, if I could start with the council, the proposal before me shows 26 affordable houses, as I understand it. What's your understanding, or how do you normally do this in terms of securing affordable housing, and why is a planning obligation necessary?
Thank you, sir. Generally speaking, we deal with affordable housing delivery via a planning obligation. Part of that obligation, and it's why we think it is necessary, is the type of delivery where there is a mix, where there's a mix of delivery between, if it's a third party, what percentages of it's social rented. So there's a lot of detail that needs to sort of be confirmed. Also, it's in relation to how they're going to remain in perpetuity. So that is basically how we think it's still necessary to have some form of requirement, whether it be an obligation or indeed a condition of where you see fit. But I think that's where our main points are in terms of the criteria, the delivery, and the remaining in perpetuity as part of the development.
Okay, thanks for that. In the council statement to me, and I noted from the planning policy that in East Whitburn you would be seeking 15% or 16 houses. Are those just for social rented, and the balance would be affordable in another sector, or do we have an issue over the actual number of affordable houses to provide?
No, we don't. It's just that's where the detail of that delivery of the mix, how it's going to be delivered between social rented and affordable, and how it's going to be delivered.
Right. Okay. Thank you for that clarification. Appellants, is that your understanding?
Thank you, sir. Yes, as you say yourself, the proposal includes the provision of 26 affordable homes that equates to 25% of the overall sites. The council's SG affordable housing requires the delivery of 15% affordable homes, as has already been set out in the appellant's hearing statement OH8. If it's determined by the council or the preferred registered social landlord that there's only investment for 15% affordable homes, then that would be acceptable to the appellant. So I think we'll leave that to the council and yourselves to determine that position.
Right. So I don't need to worry about the 25%, 15% split. That's all going to be sorted out in any future negotiations.
yes.
Good. Not worrying is a good answer. We've agreed active open space, so we don't need to discuss that. The bus stop, if I can ask the council, I'm not entirely clear. I think the position is that the council doesn't think that relocating the bus stop is practical. Is that the case, or are you seeking a contribution for relocating the bus stop?
Thanks, sir. No, the council's not seeking any contribution in relation to that. I mean, it's the council's position that the existing bus stops are, positioned satisfactorily apart on the network. They're roughly a little over 400 metres apart at the moment, which is the kind of an ultimate optimum spacing we want them to be at. We're in the position that putting additional bus stops closer, right at the junction, wouldn't really be practical. So the council's position is that the bus stops are as closely practically located to the development site as you can get already. The appellant transport assessment would seem to indicate that the 400 metre distance in PAN in relation to walking to public transport is achieved. The council has already set out some of the distances involved there, and again, these were picked up in the previous appeal decision. The council acknowledges at the present time, the distance from the north boundary up to the junction of HENS Road with A705 is 330 metres, some 140 metres further to the east to the nearest bus stop. So you're some 470 metres away from the north boundary of the site. But if you look at the housing over in the southeast corner of the site, to be considerably further away, it's if you're in the region of an additional 400 metres from the northeast corner. That's closer to 900 metres to the existing stops from the south.
Thank you for that. I understand the points you're making. I'm on a very narrow mission.
Bus stops are where they are. They're positioned appropriately for the existing road network. It's not practical to put bus stops closer, right at the junction, and therefore the walking distances to bus provision are going to be substantially in excess of the PAN recommended distances, particularly once you get away from the very northern part of the site.
Yeah, thanks for that. I'm fully aware of all those points that you made to me. I'm on a very narrow mission in this hearing session. It's just about the planning obligations and conditions in the event that I was minded to grant. But the short answer is you're not seeking a financial contribution to a bus stop. Appellant, any thoughts or comments on that?
I think just to make clear, sir, that the appellant's willing to work with the council and the service provider just in terms of resolving this. Obviously, as set out in paragraph 5.5 of the appellant's hearing statement, document OH8, the appellant is agreeable to a planning condition relating to the provision of additional bus stops. The requirement of these bus stops was set out in paragraph 6.1 of the council's committee report, that's OH3.01. And that committee report confirmed that planning obligation will be a suitable means of securing this provision. So I say the appellant has just taken that on board and proposed as they have shown in the indicative locations in document OH6.01.
But would it be your position that the provision of relocating the bus stops is necessary to make this development acceptable?
No, sir. However, we are willing to enter into discussion about that to improve matters. So the appellant would be willing to enter into the discussion, and if planning permission were granted, perhaps the council would wish to discuss that.
Okay, thanks for that clarification. And then the next bullet point, if I can ask the council, is the provision of the traffic lights necessary to make the proposal acceptable? I think you're on mute, Mr. Irvin.
Thank you, sir. Just one point in relation to the bus stops. The council's position is that at this point in time it wouldn't be agreeable to relocating bus stops. That would have implications, knock-on implications for accessibility for existing users of those bus stops. And at this point in time, the council's position is that it wouldn't be agreeable to new bus stops close to the junction. So that's the council's position on bus stop provision. In relation to the traffic signals,
Can I just stop you there?
you.
Sorry, perhaps I misheard you there. You successfully confused me. So in relation to the bus stops, you're saying you're not looking to relocate them, but did I pick it up right? That you're happy to have additional bus stops? Or
No, the council's position is that the bus stops that are there are the most the nearest practical bus stops.
Okay.
And it's not practical or feasible just to say we'll put another set of bus stops at the junction.
Yeah. Okay, that's fine. That's what I thought you. That's what I thought the council position was. Right. Let's get back to traffic lights.
Yeah, in terms of the traffic lights, I mean the council position that they're not required at this point in time. A priority junction does work, and that's been shown through the transport assessment work there. I think the issue is that the existing traffic flows on the 705, they restrict the amount of available gaps. So potentially drivers exiting from HENS Road, it may take a gap smaller than is safe. Also, you could have pedestrians trying to cross the 705 to reach the bus stops on the north side, or indeed the shop, they might find it difficult to cross. So I think on that basis, that's why the applicant is proposing to signalise the junction. So could it be signalised? Yes, if you were minded to approve the development and required it to be signalised, then that could form part of a detailed design to be submitted under a planning condition. But overall, it's not the council's position that it must be signalised.
Right, so that's what I'm seeking the views from the party, because I can only attach conditions or set planning obligations that would comply with the relevant circular. So what you're saying is the traffic lights are not necessary to make the development acceptable. So the council isn't advocating, if I was minded to grant planning permission, to include that in a notice of intention.
Yes, correct, sir.
Okay, thank you for that clarification. Appellants, any thoughts or comments on that?
Thank you, sir. I think the appellant's position is if the council consider that they're not required, then they're not required.
Okay. Mr. Hogg, have you got any thoughts on the provision of traffic lights?
No, not at this moment. I think traffic lights would probably actually add to the congestion we currently have, I think.
Okay, is there anything else we need to discuss over planning contributions? Right, can we now turn to planning conditions? And as I said, there was a good measure of agreement between you, but the appellants did make comments on the council's suggested conditions. And the first point they raised, and let's see if I can safely combine these. So they mentioned that condition 2 and condition 6 was unnecessary because that information had already been submitted. And I just wondered what the council's view of that was.
Thank you, sir. Well, it's the council's position that condition 2 is necessary. We have a drainage plan. We have where the drainage is going to go, and we have detailed drainage drawings. But however, the drainage assessment is the calculations that support that whether that the attenuation and the treatment on site is is capable or is appropriate for the development of that size. The assessment is sort of the next part of accompanying the drainage information that we have. So,
Okay.
Yep.
And what about ground levels?
The next, again, sir, we think that it's appropriate in terms of also how the levels link in with the proposed tree belts, the road levels, the setbacks from HENS Road. So in terms of the relationship with the, with the landscape itself, how finished levels, how it fits in with it, so, if a word to be granted, in terms of the, for example, a section drawing between road, house, landscaping, and again with the, in terms of the landscaping buffer on the proposed western boundary.
Okay, so if I could summarize that, in essence, what you're telling me is that whilst I have before me, I only have before me partial information on surface water and levels, and therefore it would be prudent to continue with condition 2 and condition 6.
Yes, sir. Thank you. Yep.
Appellant, any thoughts or comments on that?
If that is the council's view, then we're happy to keep the conditions in there if required.
Okay, if we move on then to C, I wondered if the council could explain the purpose of conditions 7 and 8. It appeared to me that they could be safely combined into a single condition.
Thank you, sir. Yes, I have no problem if they were combined, but as long as the points are covered.
But just give me a wee bit of background. What's the thinking behind? What's the planning purpose behind those two conditions?
So I might, okay. A phasing plan, it's more of how it's delivered in the site. We've had information on the timing of it, and it relates to the how it's going to be delivered and on what sites delivered, and it all how it links in terms of its construction delivery as well, and how the roads are going to be built in terms of its delivery, in terms of that phase. So in terms of the phase itself, all new roads and footpaths with that phase shall be built and built up to adoptable standard to serve that, and that's opposed to having, the uncertainty of having roads that sort of are being built for future delivery. So it's more of a delivery thing. Thank you.
Okay, thank you. I understand that now. Appellants, any thoughts or comments on that?
Thank you, sir. Just to say that the appellant has no preference on just whether those two conditions are combined, so we're just happy to go with the council's proposed position.
And then moving on to D. Perhaps I can ask the council, in terms of the discussion we had in the previous hearing session about maintenance, particularly of the tree belt, but presumably it would apply to any area. Would that condition have any influence on how these areas were to be maintained in the future?
Yes, and we agree that condition 9 should and could include the planting belts and the path networks that you explained. Yep.
Okay, appellant, any thoughts or comments?
We're okay with that, sir.
So I didn't quite catch that.
We're okay with that, sir. Yes,
Okay.
that's fine. We have no issue with those additional matters being included in condition 9. So
And then E, for the starting with the council, fencing details. So again, the appellants are suggesting that I already have that information. Where would you stand on condition 12?
Yes, we still, so we recommend that this condition is still, well, firstly, it is necessary, but I think it still should remain as a condition, should permission be granted in terms of details that may change in the future, its relationship with also some of the relationship between the open space and the landscape, in particular the southern amenity area. I know we've touched on the landscaping details in terms of the transition between gardens, but yeah, we still think it's necessary in terms of that, the detail.
Okay, thank you. Appellant, any thoughts or comments?
Yes, sir. If the council consider that's still required, then the appellant's happy to provide.
F. I couldn't help noticing that condition 15 is a very long condition. Other councils deal with these matters by merely requesting a scheme rather than highlighting all the various elements. Is that something open to me to consider?
So we're happy the way the condition 15 is set up at the moment, but if you feel that it'll be all covered in one scheme, council would have no issue with that.
Appellants, any thoughts or comments?
Yes, sir. If they agree with the council, if you feel that it's better to just set out in a single scheme, then we're happy to take that condition.
Okay, thank you. And there was just one last thing that it crossed my mind as I was preparing for the hearing. If I can ask the council, is there any need to condition the provisions of the solar panels? I noticed that the solar panels are sometimes shown on the house type plans and sometimes not. I just wondered if you were driving past in 2 years' time, you didn't see any solar panels, what you'd be able to do about it.
Look, thank you, sir. Firstly, yeah, we don't object to having a condition on for the solar panels, and it'll be in line with our policy NRG 1A in terms of sustainability and in terms of the housing design, and that detail can be raised for a condition. Yes, we agree.
Appellants, any thoughts or comments?
if council wish to condition it, they can. I mean, I would assume that we dealt with your building one stage or whatnot, but if this is a condition they want to put in now, then it's up. Yeah.
I mean, if you're telling me the solar panels are a building regulations requirement, then perhaps it's not necessary. But I thought the point was that this was something that you were offering over and above to demonstrate your sustainable
We're happy.
Relevant
We're
credentials.
happy. Well, yeah, absolutely. We're happy to take it as a condition. So.
Okay. Are there any other points that we need to discuss over planning contributions and conditions? Right. I'm just conscious, Mr. Hogg, that you've been incredibly patient. I hope you've had the opportunity to say whatever it is you have said. So you're happy? Okay, that's good. If you're happy, I'm happy. Before I close, then, can I just first of all confirm arrangements for the accompanied site visit tomorrow? If we can meet 9:30 at the community hall car park. I just really want to get on the site because I've seen everything I can see from the surrounding area. I've walked down the road. I've walked along the paths. I've been to see the bus stops. I've been to the existing open space. It's really the things that I couldn't easily see from out with the site. So it was things like the existing boundary treatment with Hamilton Way. It was to see the location of the western boundary, just to satisfy myself about the culverts that have been mentioned in the conditions, and also the nature of the rear of the existing house. But we can discuss if there's anything else you want me to see tomorrow. Who will be coming? Can I ask from the appellants team?
I'll be there, sir. That's Rob Miller.
Right, one. And for the council?
It'll be myself, sir.
Okay. Mr. Hogg, would you wish to attend?
Sadly, I can't be there. Unfortunately, I'm away. So
Yeah, okay,
I have to
that's fine. It's just for me to familiarise with the site. I would normally try and do these things unaccompanied, but I can't really wander around someone else's land on my own. So I'll see those who are coming to the site visit at 9:30 tomorrow. The last thing on my list is the timetable for closing submissions. So the convention is that Mr. Hogg, if you have any additional comments to make, having been present, you don't have to, but if you want to, if you can have those to me by the 8th of November. For the council, again, it's up to you. You don't have to, but if you want to, it would be the 15th of November. And for the appellants, having the last word on the 22nd. I trust that's acceptable.
So certainly from the council's perspective, that's fine.
Okay.
That's fine from the applicant's perspective.
Okay. Right, is there anything else we need to discuss? Have we done everything? Mr. McCarson.
So thank you. Just one point. I think earlier on in our discussions, there was a reference to the appeal case at Sibblesbury and Bathgate. My recollection, sir, is that you said that you would come back on that matter, and I'm just wondering if there is anything else which needs to be said with respect to that case.
Well, I think what I said is if you want me to consider an actual decision, then it needs to be before me, and someone needs to tell me what conclusions they're inviting me to draw. I wasn't sure it was crucial and fundamental to either of your cases, so I leave it to the parties. If you want to submit, if you're asking me whether you can submit another document, then you can, provided you're happy that all the other material, you're not leaving me to make up my own mind as to what you're trying to ask me to conclude.
So from yeah, so apologies to the appellant there, but certainly from the council's perspective, happy to respond to what the appellants say. But from the council's perspective, there is no need for those additional documents. I think you said yourself, sir, that we could go on ad infinitum, adding in additional documents and additional references to appeals. From the council's perspective, that was an appeal decision that was taken in a different time in a different environment. There's clearly been a number of changes in circumstances which we have discussed in some detail today. If that was a document that was to be submitted and a case was to be based around that, we would certainly, from the council's perspective, want to understand the circumstances of that decision in relation to all of the legal process which has happened since then.
Right. Well, I'm not asking. I'm not requiring any more submissions. But can I turn now to the appellants team? How do you want us to leave this?
I'll discuss that, sir, and with the client, with the appellant, and then we'll come back to you. But I mean, we may ultimately conclude that it's not required either. It was just that it was a reference in the council's committee report, but wasn't available as a document by the council before this appeared.
And I think just for okay, all I'd say is if you do submit additional documents, then I'll have to, as would be the case if there were any change of circumstances, I would have to go back to the parties, and that might delay the closing submission process. We also discussed the open space plan, but I think we're in agreement now, so I don't think I need. I'm sure it's jolly interesting, but there's an awful lot of it for me to read without an additional thing. So I don't think that's crucial. Is there any other things we need to discuss? Okay, are we done? Great. Well, thank you very much. We got through a power of work there. That's been really helpful from my perspective. And I'm grateful for your assistance and the submissions that you provided, which allowed me to do such a focused hearing session. For those on the site visit, I'll see you tomorrow. Otherwise, I'll await your closing submissions with interest. Other than that, I shall close the hearing session. So, bye.